may I have your lordship's leave to mention that item numbers 29 and 30. Day before yesterday, my lord, I had mentioned the matter. My lords were pleased to direct the matter to appear today. My lord, if it is not taken up in the usual course, my lord, may I seek some precedence tomorrow?
29 and 30. We'll tomorrow there's a different division.
Oh, but could it be, my lord, at 1:15 or sometime?
Very urgent.
Yes, this is a case of, my lord, asking for additional security deposit on account of electricity duty. My lord, I have lost the matter. My lord, I have been, the time to pay is extended till 10th of
That's Monday.
My lord, I am appearing for the licensee, my lord, in this matter. My lord, subject to my correction from learned senior friend, my lord, the matter was, when the matter of judgment was pronounced by the Honorable Single Judge, my lord, it was submitted by the petitioners, my lord. They are going to pay the money within 7 days. That is the reason why, my lord, the Honorable
Right, let us see today how far we can progress, and then we'll take a decision.
Very well.
Okay.
My lord, if it is not taken up, my lord, kindly permit me to mention tomorrow.
Yes.
My lord, may I have your lordship's kindly. My lord, yesterday your lordship was pleased to grant us leave in that tender matter where,
Yes.
my lord, your lordship said that if it is servered, my lord, yesterday in the night at 8 o'clock, the order has come on the server. So, my lord, today at 12 o'clock is the auction. So, my lord, I have been held to be disqualified.
And who
So I have not been able to participate.
who will be for the respondent?
My lord, they are all here. The DVC and injunction, they are both here. Mr. Sen is for Damodar Valley Corporation.
All right, you file it, leave granted. Let us see. Let the matter be numbered and brought.
Very well.
You please.
Very-
Supplementary list we can make.
My lord, in compelling circumstances, my lord, I am mentioning, my lord, item number 22, my lord, this matter relating to, my lord, invocation of bank guarantee, my lord. And this matter was taken up by your lordships on 22nd June, my lord. On the date, my lord, the respondent did not appear, my lord. So, my lord, the lordship directed me to, my lord, serve copy upon the, my lord, learned advocate who are appearing in the trial court. My lord, I have served, my lord. It is very urgent, my lord, invocation of bank
All
guarantee
right, we'll take it up today.
today.
With my lord's
If, my
kindly,
lord, not taking up, my lord, kindly take it up, my lord, and next,
Well,
my lord, we are
We'll
going to
see.
stay, my
First
lord.
we'll start
with my lord's kind indulgence, I am mentioning a matter which is urgency in the sense my client is in the 100 years old, in the deathbed, covered by my lord's judgment. It will not take more than 2 minutes time, including the delivery judgment. My lord, the freedom fighter matter, area of pinch.
May I have a lordship's leave to pray?
During the
Have it, let us see. Freedom fighters. Right. Yes.
May I have a lordship's leave to pray for leave to file my appeal without the certified copy? Great.
Lordship, may I be permitted to pray for leave for filing an public interest litigation, Lordship? The Panchayat election candidate puts his pictures upon the national flag and doing the campaigning, Lordship.
You file it, no urgency. We'll see.
My lord.
Today we will see. You inform the council for the election commission.
Advance copy I will serve.
No filing. You give this set of papers to the council. We'll see. 2:30 there's a matter.
My lord, I am
Great embarrassment, my lord. There is some matter, my lord, which will, there's some amount of urgency, my lord, because of the simple reason, my lord, there's a no coercive order passed till 15 July. But today it's not, it's item number 31, my lord.
We will see how far we progress.
No, if not that, could your lordship anytime after 2 or tomorrow first thing, my lord, if your lordship,
Tomorrow can't be, Monday. If it doesn't reach,
Monday lordship takes up the pill matters.
oh, pill matter. This
So
is
the Monday to then I go to the next Wednesday. That's why, my lord, I'm troubling. Otherwise,
what is the item serial number?
item 31.
31. Let us see today.
Very good.
We'll make a note. Please call.
Thank you.
my lord, I am one mentioning, my lord. I am praying leave granted for filing to read petition before the circuit bench of Port Blair, my lord. Therefore, my lord, grant leave, my lord. Yes, their bench not available there now,
Yes.
my lord.
Please call the list. Call.
Item 338 of monthly list, my lord. In this matter, my lord, I am for the respondent initial as well, my lord. We have issued a banning order, my lord, that was set aside by the Honorable Single Judge, my lord. Now, my lord, we had filed an appeal that is pending before your lordship, my lord, and they have filed a contempt application, my lord. They have mentioned this matter.
Item 69.
338, my lord. Item number 330.
You want upgradation?
Upgradation. My lord, otherwise, my contempt, if they move, my lord, the contempt, my lord, on 14, it has been.
You make a mention on Monday.
appellate side, monthly list, serial number 1.
Yes.
May it please, my lord, this is the matter of the railways, my lord, where I was placing, my lord, for Mr. Bhattacharya. My lord, kindly see the impugned order once, my lord. Here, if this order is to be complied with, then, my lord, in my humble submission, the safety and security of the railways will be at stake. Why I say so, kindly, my lord, take the interim order, the final order once, my lord. May I just place it so that, my lord, the entire situation comes absolutely clear. I will place it entirely, my lord, and then I will make my submissions. Otherwise, my lord, the order
But it was heard by the other, the composition was different.
composition was different. It's entirely for my lord, but
Your lordships had not heard it for very long.
We had passed some order also.
yes. The only order that was because contempt is there, my lord, tomorrow at 3 o'clock, and cost of that has been kept in abeyance, personal appearance.
But if you can just seek for an adjournment in the contempt.
I'll tell you, lordship, my lord, that is not a problem. I could certainly seek for an adjournment. My lord, the problem is, my lord, because of the non-inspection or my lord rejection, my lord, wrongfully of my goods, my lord, which have met all standards, all my lord concerns are addressed. My lord, today, my lord, there are creditors to the tune of 71 crores, my lord, which are, my lord, hounding me, my lord, coming with hooligans to my door, my lord, beating my door down for money. And well, I cannot pay that simply because, my lord, the railways is wrongfully refusing to accept my
My lord,
goods.
this
That
is
the
not
only
on
problem.
affidavit. This entire submission is from
And
the
my lord,
bar.
they have written emails, they are writing
No.
letters, my lord.
When is the contempt listed?
My lord, tomorrow at 3 o'clock, and my lord,
That what we'll do is we'll constitute the same bench next week. We've got a couple of more matters also. Myself and Justice Ajay Kumar Gupta, probably next Wednesday or Thursday. In the meantime, you can seek for a week's adjournment in the contempt.
Well, we'll do that. Well, there's no
kindly pass
difficulty.
an order because my contempt is, my lord, and my lord can take it any day, anytime with whatever. But my lord, kindly consider this, the gravity of the situation, and they are also filed, my lord. My lord,
We have followed your lordship's, my lord, observations. Your
no,
lordships
no,
may be
kindly
rest assured that, my lord, we will make that representation. We'll also
no,
say.
my lord, kindly pass an order. But why I say so?
Yes, yes. We have heard the learned advocates for the parties. This appeal was heard by the division bench consisting of the Chief Justice and Honorable Justice Ajay Kumar Gupta, and certain interim directions were passed on 21/6/2023. Therefore, the matter has to be heard by the said division bench. Let the matter be listed next Thursday before the said division bench. It is submitted by the learned advocate appearing for the appellant that contempt application has been filed by the respondent writ petitioner, and the matter is listed before the learned single bench on 7/7/2023. We have requested the learned senior advocate appearing for the respondent writ petitioner to seek for an accommodation before the learned single bench, since the division bench is seized of the matter. List the matter on next Thursday.
Will it be a lordship's pleasure to, my lord, keep it at the top or fix it at 2 o'clock? Very well. I'm very grateful.
2:30 PM, 2 or 2:30 PM or 2:30 PM.
I'm very grateful.
Deeptesh, you inform Justice Gupta today itself, so that he is sitting with Justice Jalmala. 3:30 we'll have it.
Yes.
Because he just Gupta.
Well, whenever it's convenient for the bench.
No, yes, my lord, we also, whenever it's
Because Justice Gupta is sitting with Justice Joymalia Bakshi.
I see.
And that division bench is hard pressed for time.
Lord, we will be here whenever it's convenient for your lordship.
3:30.
3:30, very well.
Today itself.
deeply obliged, my lord.
We just hope that there is no resolution for 3:30.
No, my lord, we are also anxious. Deeply obliged.
Yes,
Serial number 2 and 3.
yes.
Item 2, my lord, as we understand, my lord, all of us are going to pray for accommodation on various grounds. Petitioner is going to pray for accommodation on the ground of Mr.
Filing reply.
Filing reply.
Yes.
So this is the Menekara scheme.
The Manrega scheme.
Yes, my lord. I'm for the petitioner, my lord. So the affidavit on behalf of respondent number 1 as well as respondent number 2 to 27 have been filed, my lord.
Very good.
It was served upon us on 27th and 30th of June. So my lord may kindly grant us 1 week's time to file reply, my lord.
My lord, in item number 3, my lord, I am appearing on behalf of the Union of India and I'm praying for 2 weeks more time to file the affidavit.
Lordship,
You have, your, any affidavit on your, not. Okay.
Lordship, I am for the petitioner in item number 3, Lordship. The state had filed their opposition
We'll
without
grant
reply.
grant you 2 weeks' time.
Lordship, my reply is ready, if I may be.
You serve copy.
I have served the copies of.
Rare case where state is not the defaulter in filing.
Malad, maybe file, Malad, in item 2, maybe file our affidavit, Malad, in
All
terms
right.
of Malad.
Whatever it is, you note down, no? This affidavit, that affidavit, as jointly prayed, is the matter on 27th, sir.
27, sir. Great.
The learned advocates who wish to file, the parties who wish to file any affidavit shall do so within the set time after serving copies on the learned counsel for the other side.
Great.
Grateful, your lordship.
Serial number 4 and 5.
But 4 and 5, we have submitted our written submissions of our, my lord.
4 and 5, my lord, the election commission had made its submissions. I don't know, my lord, where Mr.
State is to argue, my lord.
Page number 25.
The notes I have, I'm bringing.
Your lordship director has filed a report
Yes, it's
within a few minutes.
Yes, it's on
It's
the.
on the.
It's on the way. Then who else, anybody to make
My
submission?
lord, the state, my lord, was represented by the Advocate General. My lord, he said he would also file a written note.
So that's, then everything is complete.
I think so, my lord. I think so.
Your lordship.
We'll
without
reserve
wasting the
judgment.
time, pass it over, my lord. Without
No.
wasting the time.
No, this, I think, if you want to make further submissions, we have elaborately heard, in fact.
We have to, my lord,
I will file, I have already.
I'll file within the
stated.
next
Only written submissions.
Yes.
The learned advocates for the parties have filed their written submissions. Orders reserved.
kindly permit me to file it with your lordships and officers within the next hour.
Yes, yes, yes. We have recorded as if all of you have
Yes,
filed.
yes.
Your Sonal, you serve your friend. Copy, advance copy.
Very well.
See,
but
you should have sent
we have not
soft copies to them.
there-
I will.
You should have sent
They
it.
didn't send it to us, so I.
we have made our argument. They didn't made their argument. State file করবে না?
Yes, orders reserved.
Grateful, your lordship.
Order is up, my lord.
Yes,
On the state will not file their notes of argument.
they will file it
They will.
during the course. If they file well and good, otherwise it's next.
Serial number 6.
One side. Report, বলো।
Yes. Your report had been filed. Advocate is not here. You are appearing.
Yes. কোনটা?
Shamal, na Shamal Mandal.
In this matter, I am not appearing.
All right, let us see. Pass over. Yesterday also it was passed.
We are always there, your lordships.
Serial number 7.
Same, my lord, same order.
Or we'll say none appears for the petitioner. List next week. Next week it's unwanted.
My lord, kindly pass over, my lord.
Pass over.
My lord, he's engaged on courtroom number 18, my lord. Please pass over, my lord.
All right, pass over. Item 6 and 7, is it? No.
Yes, my lord.
6 and 7.
8.
Serial number 8.
Yes.
In this
But,
matter, your lordship, I'm led by learned senior advocate, Mr. Kishore Datta. He's on his legs. I will inform him.
You want a passover?
You want a pass?
No, I don't want. তুমি কি চাইছো?
Allegation is,
I'm appealing for Union of India. Is violation of model code of conduct. Lord, and we lodged 4 complaints to the election commission. 4 complaints to the election commission. But I tell you, lordship, one by one. Lord, there was a project brought in by the state government as Lord Sorasori Mukhyamantri. Lord, kindly take Lord page 30 to my complaint, and Lord the pleading. I will take you lordship to the pleading, Lord. Kindly Lord first take Lord only one paragraph of the petition, para 6. Kindly allow me to place it for you. Page Lord 5, para 6.
yes.
The Chief Secretary of the Government of West Bengal issued an order dated 6 June, just 2 days before the declaration of election, announcing a program in the name of Style Sorasori Mukhyamantri, direct reach to the CM, which was made with the effect from 8 June. That's the date when the election was declared. Further direction was passed by the Chief Secretary directing all departments are to assign a suitable officer to receive grievances, suggestions, etc., and had also assigned a phone number. Now, this is very important. At this juncture, it is pertinent to mention that the very same phone number is used for the political program of Trinamool Congress known as Didi Ke Bolo. So, the government
And
has...
what is the scheme?
Lord, Sorasori Mukhyamantri, Sorasori means direct. So you reach direct to the Chief Minister. That's the project launched by the Chief Secretary on 6th of June. 8th of June, giving a particular phone number. That phone number is the phone number of a project of the Trinamool Congress, which is called Didi Ke Bolo. Call up Didi. Lord, we call our Lord beloved Chief Minister as Didi.
Yes,
Lord.
yes.
So Didi Ke Bolo. So Lord, the party's number is being used as the state government's project number when the election is in motion.
Any action taken by the commission on this?
Lord, this is not the only one thing. There are 4 aspects, Lord. I want to draw your lordship's attention. This is one. Then second is, after declaration of election, kindly take Lord page 35. Page 35. Kindly have a look at this allegation that we have made. This is very, very serious. To draw your kind attention to a news report carried by News 18 Bangla, in which TMC candidate Jalpaiguri Jela Parishad Dinesh Mojumdar is very clearly seen distributing money to a number of people. We draw your attention to this provision of MCC, general conduct we have quoted. We demand immediate step be taken by the commission against the TMC candidate. Nothing done. One more very important aspect, Lord, we have specifically alleged against the SP, Lord, Purbo Midnapur. I have in a paragraph categorically stated, Lord, what he is doing to frustrate the election process. Kindly take para 16. And a specific complaint was lodged. Para 16. Lord, kindly allow me to read para 16A only.
1 second. Yes.
Now, Lord, kindly allow me to place 16A. The petitioner said that the following instance would show how Sri Amarnath K. IPS, being Superintendent of Police Purbo Medinipur, has been acting in a manner dehors the manner in which an officer of an All India service is required to act. On 1st June 23, there was a political event in the district of Purbo Medinipur, wherein an MP of the TMC party along with some other party workers walked in a procession from Chondipur to Nandigram. Sri Swanso would be seen walking alongside the TMC party workers, covering a very long stretch of procession. It would be extremely unconvincing to say that the SP of a district had to personally take part in a political procession to ensure that the security arrangements were in place, while disregarding every other law and order aspect of the whole district. The petitioner craved leave. Lord, we have said in other paragraphs also, kindly take para B. On 16th May, a blast occurred at an illegal crude bomb manufacturing unit at Khadikul. Your lordships will not have directed in Lord NIA Lord investigation in this. This was not the first time that Khadikul had been rocked by explosions. There were explosions at illegal units operated by Sri Swanso as well. During one of such explosions, a former Trinamool Congress Panchayat member lost his brother, but illegal units continue. Judicial notice was taken. So and so. See, furthermore, only 6 months ago, December 22, blast took place at Bhupati Nagar. There also, my lords, my director NIA, about 40 kilometers from Khadikul, which took 3 lives. The explosions at Khadikul, where a majority of the victims were women, and raised questions on Sri Amarnath so discharging duty as SP, and was reluctant to take any measure against such illegal crude bomb manufacturing unit and firecrackers factories, since such factories were owned and operated by leaders belonging to ruling dispensation in the state of West Bengal. It is pertinent to mention herein that had Swanso had been efficient, he could have scouted for such operations, and in the district, and the Khadikul incident would have been averted. It may also be mentioned that Chief Minister of West Bengal had also acknowledged that administrative failure. Then even after this incident, SP Purva Midnapur Swanso himself rushed to the spot and take stock of the situation. However, when the FIR was registered, charges under explosive substance acts was not included. Vijay Krishna Bhuiya, a BJP booth president of Bakla Panchayat area in Moyna block, Purva Midnapur district, was murdered by goons affiliated to the ruling dispensation in the state. The victim's family, in their complaint to the police, had named 34 persons. The police, on instruction of Sri Amarnath K SP, Purva Midnapur, had lodged FIR against unidentified person. Police was reluctant to arrest them. On 15th May, Purva Midnapur district police barged into the official legislative Karyakarta at Nondigram without prior intimation. They did not have any search warrant, and we have stated all this to show that he is not doing his duty. He is not participating in the Michil of the Trinamool Congress, the ruling dispensation.
So
But we prayed for that he should be transferred.
broadly, there are three issues pointed out. One is regarding the whatever is the program, phone number. The other is against the Supunda police, and as others in respect of a incident where a bomb explosion.
No. Second is illegal distribution of money, my lord. That is we have alleged page 35. Third is that the SP Purva Midnapur, he is not participating, is performing his official duties. He is not participating in rallies of Trinamool Congress. That is why we have said that there have been 3-4 bomb incidents where he could not do anything, but he is being seen in the participating in the Michil of the Trinamool Congress. And fourth, kindly take page 37. Lord, they are transferring officials. Kindly take page 37. 30.
Yes, 37.
Yes. Yes, please. Lord, kindly allow my senior to take over. Lord, he has come. Lord.
Yes.
Please take over. देखिए दाओ तुम ही देखो मैं बोले छी देखो ना
At page 33, if your lordships will kindly take note of.
बोले छी इतने देखिए दिए छी instruction
Yes.
And that's the complaint note with regard to transfer. And the evidence is at page 37.
No, it says
The
that
transfer of election, police
issued
personnel.
by the IGP personnel transferring 10 officers.
Yes.
Said communications be issued complete disregard. Without the permission of the commission, they could not have issued.
Not have done.
Yes, that's the fourth point. That's the fourth point.
Yes, sir, Mr. Dattu, what is
And
your?
the fourth point is, although the commission said that there should be no leave granted to officers.
That we saw.
Yes, now not as of today, not 2 minutes back, the information received from Purva Medinipur is there are 4 buses loaded with armed personnel from another district coming to man the election.
Army personnel?
Not army personnel.
Oh.
Political personnel. I mean goons. 4 buses load of personnel. Armed personnel.
Yes, sir. What is your instruction? Why is the scheme or something? Telephone number is saying.
But
Small issues. If it comes to your notice, immediately take
but
action.
it ought to have been disposed of by this time. Let me take the instructions for whether these have been disposed of or not. May I come back and say around 1 or 1:10, subject to your lordship's permission.
All right, pass over.
We will come back at 1.
Next.
The matter was passed over, Matt. I'm extremely sorry, Matt.
I appear for
Other is present.
item 9 too.
Serial number 9.
My lord, 9, my lord, this is my appeal, my lord, learned AGP, my lord, Mr. Siddiqui is appearing in this matter, my lord, kindly, my lord, not this week, my lord.
Well, I have no difficulty, Lordship. The only thing is that this is the order passed in September last year. Order, now for the first time they are moving. They have violated the order.
Contempt file.
Contempt file, contempt notice issued. Now they, and only thereafter, contempt recorded that they have violated.
Pendency of this appeal will not bar you
Lordship,
from
kindly record that, otherwise they will go and say this one.
the learned advocate appearing for the appellant seeks for adjournment. Though the prayer sought for is not opposed by the learned senior advocate appearing for the respondent, is submitted that the order impugned in this appeal was passed by the learned single bench on 22/9/2022. And for non-compliance of the order, contempt application is pending. We make it clear that the pendency of this appeal will not be a bar for the learned red court to proceed with the contempt application. List the matter after 2 weeks. You give a date after 2 weeks. Next.
27 July. Serial number 10.
Lordship may consider putting rubber stoppers on the chairs. Otherwise, I just
No, I've
came in.
already informed, sir. Actually, it should be rubber stopper.
Rubber stopper.
But some other material, they didn't know. The registrar has seen the matter. So we'll do that. Very noisy.
Very noisy. I came.
Lord, I appear, my lord, for the appellant.
And I am appearing for the writ petitioner respondent.
Very urgent matters.
My lord, I'll tell your lordships. My lord, there is one interim order, my lord, which I need. But before I start this matter, I must apologize for item 4, my lord. I wasn't fast enough. My lord, your lordship said I can give a note. I have a note, my lord. My lord. Yes, my lord, I'll just do that. Now, my lord, apropos this matter, my lord, there are, my lord, I'll just indicate, my lord, very briefly. My lord, there is, my lord, what we refer to, my lord, as the DVC command area. My lord, DVC, my lord, Damodar Valley Corporation is, my lord, an interstate river valley project and, my lord, electric company. So, my lord, DVC, my lord, the stakeholders are the central government, state of Jharkhand and state of West Bengal. DVC command area means, my lord, where DVC supplies electricity. The region, my lord, is, my lord, areas of state of Jharkhand as well as, my lord, state of West Bengal. It has consumers at both places. Now, my lord, the tariff, my lord, which is determined for DVC, my lord, are, my lord, by two, my lord, regulatory authorities. One is, my lord, the West Bengal State Electricity Regulatory Commission and, my lord, Jharkhand as well as, my lord, the central. So, my lord, they are all, my lord, involved in determination of tariff. Now, in this area, my lord, we have, my lord, people who, my lord, consume, my lord, huge amounts of electricity because of arc furnaces and, my lord, the industry which is involved, steel and ferroalloys, my lord, is, my lord, the main industry. So, my lord, West Bengal determines, my lord, form, my lord, the distribution licensees who are situate, my lord, in West Bengal. The appellant before your lordship, my lord, is the West Bengal State Electricity Distribution Company Limited. So, my lord, there are areas where it supplies, which falls within DVC command area. Now, my lord, what transpired was the tariff determination, my lord, of, my lord, West Bengal State Electricity Distribution Company Limited was higher than that of DVC. So, my lord, consumers in the DVC command area started migrating to DVC. Now, my lord, in the tariff order, my lord, which sanctions tariff, there was, my lord, a proviso that if, my lord, there are multiplier, my lord, distribution licensees operating in the same area, then, my lord, a competitive tariff scheme, my lord, could be, my lord, invoked by, my lord, the distribution licensee, in this case, West Bengal State Electricity Distribution Company Limited. So, my lord, such a scheme, my lord, the competitive tariff scheme was, my lord, was framed, my lord, on 15th of October 2015. My learned friends clients, the writ petitioners, my lord, applied under that scheme. My lord, according to us, my lord, there was a delay in them, my lord, applying. So instead of 15th October 2015, from February 2016, my lord, we made available that benefits of that scheme to them, which was a lower tariff, my lord, matching, my lord, DVC. They challenged that. My lord, they succeeded. And my lord, we have complied with that portion of the order. So my lord, appeal, my lord, from that portion of the order.
No, from February, why did they challenge this?
My lord, they said it should start from October, the date the scheme came into
They
effect.
succeeded in getting.
They succeeded. So my lord, we have, my lord, given them the benefit. So there is no, my lord, question of challenge, my lord, there. Now, my lord, the second scheme, my lord, which, my lord, was, my lord, framed, my lord, it was, my lord, a revenue, my lord, the exact name for it, my lord, is Revenue Enhancement Scheme. Now, moment this competitive tariff scheme was made available to steel companies in DVC command area, in West Bengal, other steel manufacturing companies said, well, you are giving steel manufacturers in a particular area a benefit. You can't do that. You have to make available the same rates to us. So, my lord, what did we do after getting these representations? We said, well, we can devise something which is provide for a rebate if there is larger consumption by you, because economies of scale come in. So if you take large amounts from us, so your fixed charge goes up, etc., we'll give you a rebate so that the tariff matches that of the DVC command area. My lord, so we framed this scheme. Since it was not part of the regulation order, the earlier order which allowed, my lord, reduction in tariff where, my lord, there were my lord, distribution licensees, we made an application to the Regulatory Commission. The Regulatory Commission allowed that scheme and says it will come into effect when you notify that this scheme is operative. And secondly, we give you permission to choose the customers to whom you will apply this scheme. My lord, the scheme was made operative and the notification said it will apply to areas which are not governed by the DVC command area because they already have a competitive tariff scheme. Now, my lord, Kalimata was in the DVC command. It got competitive tariff. So, my lord, it's lower. It said that I have to get this benefit of this tariff scheme as well, because otherwise it's discrimination. My lord, the learned judge, with the greatest of respect, my lord, overlooked clause 6D and the publication which had been made saying that it will not apply to, my lord, the DVC command area, and said you make available that to them. Now, my lord, if that is the case, my lord, West Bengal State Electricity Distribution Company Limited, my lord, to start with DVC command area, my lord, consumers will get double benefit. And my lord, the tariff which we have to start, my lord, will make it, my lord, completely unworkable. So, my lord, they have been paying, my lord, as far as, my lord, taking benefit of only, my lord, the competitive tariff scheme. My lord, they can continue to pay. All that I'm saying is that, my lord, I should not, my lord, the direction for me to make available, my lord, the revenue enhancement tariff to them, my lord, should be straight. That's all that I'm asking. I can show your lordship clearly what has been missed out.
Then appeal has to be heard.
Correct. But, my lord, that portion, my lord, that tariff, my lord, I should not, my lord, make available to them. I can show your lordship straight away.
If suppose you insist upon that to be
we have not
extended.
till now, we have not recovered anything. We have not claimed anything till now. The order has been passed a long time back. We have not claimed anything because the first
So
part.
let the status quo which is prevailing as on date may
My lord,
continue.
only thing, my lord,
Probably we fix sometime in.
we have also not filed any contempt. We have never claimed also. My lord, so the contempt doesn't come. My lord, only thing, my lord, would kindly take this. This stay petition is of 415 pages. But just this is the entire writ petition opposition reply. Now with my learned senior friend appearing, the entire there has been a paradigm shift from the stand taken earlier, And now, my lord, what has
Now,
happened, my lord?
these
The-
documents.
No, my lord, I'll tell you.
Most of the documents.
My lord, I'll tell you, lordships, my learned friend raised an objection last time. My lord, for today, my lord, I won't rely on them because I'll show your lordship what was before the court and my lord, the document which was ignored. That is the notification which said it would not apply to DVC command. But my lord, the additional documents which we've got in to show the representations, my lord, of the steel manufacturing companies, I filed an order 41 rule 27, my lord, which is also there. I'm not, my lord, I've annexed it here, but I've also made, my lord, an order 41 rule 27, which your lordships can consider at the time of appeal. My lord, if my learned friend wants to deal with those, my learned friend can. But my lord, the main document is at page 205, which your lordship just has a look at it. My lord, in 1 minute, my lord, it will be
All
clear.
right, we'll fix it up sometime in August.
Very well, my lord.
July is difficult.
But only one thing, my lord, would find this.
You file your affidavit to your, opposition. If you're opposing these documents, if you're opposing they have filed an order 41.
Well, yes, my lord, we want to file it, my lord. My lord, only one thing, my lord, the court has recorded. The scheme which my learned senior friend was only restricted to consumers outside the DVC command area, but the scheme specifically says it is for all, and that is recorded, my lord, that is recorded.
Of course, without hearing you, can you have the benefit of both?
My lord, if the scheme says, my lord, I am not the eligibility criteria was difficulty is, my lord, I had enhanced my infrastructure. The moment I saw the notification, I enhanced my infrastructure, invested a huge sum of money.
Draw more electricity.
Yes, I put in more workers so that I have 24 hours of service. So consumption to meet that requirement. Now suddenly you say that this is, my lord, and this subsequent notification is something which is subsequent to my application.
All right. Instead of filing a writ petition, could you not have gone to the regulatory commission?
My lord,
by way of an interlocutory application?
my lord,
Because
WBSC
this-
had disposed of the matter. I was not a yes, I
You are
was
not a party to
no,
that.
my lord. Difficulty it was between WBSC, the regulatory commission,
true,
and the
sir.
licensee.
See, these are all, technical matters, and
My lord,
they have been given permission by the commission to do X, Y, and Z, fix a cutoff date, choose the consumer, etc. But while implementing that order, this problem has occurred. In all probabilities,
May I
you
say,
should have-
there is no disputed question of fact. This is a pure question of law. My lord, this is
but
subject to
still, it
my lord, subject
concerns
to
the
correction.
tariff. No?
There are also judgment that the regulatory commission cannot decide on issues which is interstate disputes by a consumer who has come with the dispute. There are judgments subject to correction where the consumers
So
dispute.
this may be probably whether the benefit is extendable
My lord, the
to
benefit, my lord, with subject to correction, my lord, competitive benefit is part of the Electricity Act, Section 62, first provision. Next benefit was given. I can show from the order, my lord, my learned senior is not relying on a document today as well. I can show, my it was specifically stated all industrial units. All that was what I had shown to the honorable single judge. On that basis, my lord, the order was passed that there is no
but
demarcation.
the AG says that clause 6 or something is
My lord,
there,
I'll show your lordship straight away, my lord.
except
Yes, my lord,
PVC.
kindly come to page 56. My lord, this is the order. "56, my lord, is the order. My lord, kindly see, my lord, clause 6, page 58. The commission, after due examination of the said proposal, along with the scheme submitted by W so-and-so, is hereby pleased to accord approval to it for implementation of the said scheme, subject to the following." Kindly take D at the bottom. W so-and-so shall publish a notification in this regard, clearly mentioning the rate of rebates. Now, my lord, kindly note. And the applicable consumers before introduction of such scheme, both in newspaper and website of SEDCL. Now, kindly come to page 205.
No, sorry.
My lord, kindly come. My lord, kindly come to page 205. And this was a document before the learned single judge. My lord, newspaper, notice, lordship has that. Kindly come to the penultimate paragraph of that notice. The rebates as allowed vide order dated 8th February 2017 of WBRC and notified by so-and-so on 10th February 2017 shall not be applicable for the consumers availing competitive tariff. And competitive tariff is in DVC command.
And how does the learned judge get over
My lord,
this?
kindly, my lord, I'll show your lordships. My lord, kindly take the impugned order, paragraph from the memo of appeal, my lord, paragraph, my lord, 26. Please, please. Now, my lord, kindly see. Para 26, my lord, is dealt with. Now, para 28. It is seen from clause 6 of the order that subclause B thereof stipulates load factor will be in addition to the rebates allowed. Now, my lord, what was competitive tariff is not a rebate. Then, my lord, as such, the line of distinction sought to be drawn between consumers enjoying competitive tariff as for so and thus not enjoying such is artificial and not sanctioned. Subclause D, now my lord kindly see, says that shall publish a notification mentioning rate of rebates and applicable before, both in the newspaper, the concerned scheme, a copy of which is that clearly stipulates that exemption was intended for so and so. As such, the expansive language of the scheme read in conjunction does not leave scope for discriminating consumers, principle envisaged so and so, etc. Could not be a relevant in the absence of any distinction, etc. The advertisement notification, my lord, is completely, my lord,
Where is your affidavit in opposition?
my lord, yes, my lord, kindly take, my lord, 411, my lord, is the affidavit in opposition. And my lord, your lordship kindly comes to, my lord, page 414, subpara I. This is para 3, subpara I at 414. Lordship has that, my lord. On May 8, 2017, it was notified by West Bengal State Electricity Distribution Company Limited that the rebates as allowed vide order dated February 8 of so and notified by so on shall not be applicable for consumers availing competitive tariff. Copy of notification, and that's what I've shown your lordships at page 205. Now, my lord, may I show your lordship one more thing, which was not, my lord, seen by the learned single judge, page 129. My lord, this is part of the scheme. Kindly have a look.
Well, the scheme was not there before the honorable single judge. The scheme was never produced by the W.
No, they are wanting that scheme. They should have produced it and shown the court.
But this is not in public domain.
No, my lord, kindly have a look at the background, my lord. That's what I'm saying. Background, electricity consumption for 33 kV and 132 kV industrial consumers of different categories has fallen by 15 to 40% from so and so. This results in reduction in revenue and subsequent increase in distribution loss. Furthermore, mainly power intensive are not able to sustain the cost due to lower tariff in DVC command area. In order to boost up industrial sale by removal of disparity of tariff with DVC and consequential dissatisfaction as well, subsequent improvement. This was the basis, my lord, of the scheme. And the order approving this scheme gave us, my lord, liberty, my lord, to, my lord, also say from when and, my lord, the category of consumers.
With regard to the maintainability of the writ petition, any ground was
My lord, I'll be fair, my lord. It doesn't appear. My lord, I was not there, my lord, before the lunch. But my lord, affidavit.
I take 2 minutes to respond to this. My lord, with deepest respect, that notification my learned senior shown was not passed pursuant to this order. My lord, kindly see just 2 things. The order page 57, my lord, paragraph 2. I just want to show. My lord, what was the background and what was shown before the regulatory commission. Page 57, my lord, paragraph 2. It has been submitted by WBCDL in their application that the commission vide its letter dated so and so requested WBCDL to send a proposal to resolve the disparity in power tariff between Damodar Valley Corporation and WBCDL. It was not, my lord, it was never, at least, my lord, it was not there that it should be restricted to the people who are outside the command area. It was not there. And now, my lord,
all right.
Well, just see the
No,
notification. Well,
see, how can you have a benefit?
well, kindly see the notification.
Please, sir.
Tender.
You are thorough with facts, we are not.
No.
Admittedly, it's a concession. Initially, with command area, etc., your representation of all the industries were considered. And probably X benefit was granted. Now, the other people said they had been discriminated. They went before it and etc. They passed an order. The others would. But the commission said the distribution company will be at liberty to choose to whom they will extend the benefit.
I'm grateful.
So therefore, the other set of consumers claimed that they have been discriminated because of industries in the command area getting a concession. And now you say you get that benefit and you say the other person is getting a better benefit, I am being discriminated. You give up this
But
and
I'm
choose
not
the other.
subject to, I'm not getting this benefit only because I'm within the command area, or I cannot be discriminated because I'm within the command area. Madam, to kindly come to page 60. Madam, kindly, madam, just for my satisfaction.
All right, we'll fix it
Madam,
up,
2
sir.
minutes. I just show why the Honorable Singh just said what. Madam, page 60. Madam, kindly page 60. This is the notification. Madam, kindly page 60, the last line. The notification has been published as per the direction of the Honorable Commission VDA order dated 8 February 2017. This is the notification, not the notification which was shown at page 205. Kindly see this notification. Next page, 61. And this is 10th February. My lord, the order was of 8th February 2017. This notification is of 12th February 2017. Kindly see one. Scheme for revenue enhancement through increased sale to the industries supplied at 33 kV and 32 kV under WBCDL through rationalization. Exemption in demand charge for additional drawal up to 50% from existing 30% during off-peak period for all 33 kV. Well, this was the thing for all 33, 132 kV. Kindly come to the next page. Kindly come, my lord would find this all everywhere in the scheme. Well, this was notified. And this was done pursuant to the direction of the Regulatory Commission. Now, subsequently, when I have applied, well, now they say I have applied in the month of March. They have come out with a notification without saying anything about this particular notification. They say this cannot be extended to the consumers within the command area. But this is pursued now. Kindly
because
62.
No, the notification at page 205 says that shall not be applicable to consumers availing competitive tariff.
Kindly see the last line of this notification. This
Above
notification has been published as per the direction of the Honorable Commission.
No.
I attended. This last two lines has been published with the consent of the government of West Bengal dated 23rd September 2015. Order Regulatory Commission's order is of 2017.
Yes, 8/2/17.
How can this notification be published in terms of the order of which precedes the order of the Regulatory Commission? Kindly see, all kindly see 61 for my satisfaction, page 62, 62 one just.
Yes.
Kindly see eligibility condition for existing industries specifically says.
So they don't make a distinction.
No, that was the thing scheme. Well, that was submitted, that was accepted. That's why the Honorable Single Judge says all have been allowed. This is the eligibility criteria. I fulfilled this. I have specifically pleaded that in the petition, not denied in the opposition. Specifically, I shown for all consumers. And the subsequent notification, it was done something, and this is not a notification with deepest respect,
But you had sought for quashing this portion of the notification.
This was not there within our knowledge. So I showed to the court.
This is public notice.
Yes. That was pleaded, but fact remains, this notification will prevail because this particular notification has been passed in terms of the order of the Regulatory Commission. But this is, kindly see, how can a notification take into consideration of facts?
So according to you, this restriction is contrary to what the commission has said.
Yes, absolutely, this this is the licenses notification.
So even in the notification at page 60,
yes,
they don't exclude
the
industries in the command area.
And this is passed pursuant to the direction of the Regulatory Commission. That is what I wanted to show. And this is the 62 says this is the eligibility criteria. I fulfill fulfilled those eligibility criteria. I enhanced my infrastructure, and now, my lord, they suddenly say, and I had applied in the month of March. That 400, I had applied in the month of March for this, and this subsequent notification, May 2017. I had already applied for this.
So
Well,
this
this requires varying,
notification
my
at
lord,
page 205
Yes.
doesn't refer to the.
Yes, it does. Now, my lord, kindly take, my lord, 3 paragraphs above the 2 paragraphs above. Rebates as allowed V-Day order dated 8th February 2017 of W so and so and notified on 10th February 2017, which was shown, shall not be applicable for consumers availing competitive tariff.
So this, according to you, this covenant is in consonance with the.
Yes,
Uh,
6D, my lord,
6D.
6D, and my lord, what has been, my lord, shown to your lordship, my lord, at page 60. My lord, kindly come to page 60, my lord,
Yes,
which is the order of 10th February,
yes.
which is referred to in the notification.
Notification.
And my lord, it says that this will apply now, my lord, to only, my lord.
You could have challenged this
And there's,
portion of.
and
the-
I disclose it, my lord, in my affidavit in
or to
opposition.
say that the declaration to declare this restriction be inconsistent with the direction of the commission. But one thing, sir, the commission has granted them liberty. If you go back to the order, it says, page 58, WBA so-and-so shall publish a notification in this regard, clearly mentioning the rate of rebates that has been mentioned and the applicable consumers before introduction of such scheme. So that should have been declared as null and void beyond the scope of the order and direction of the commission. But the commission has been given, given them liberty to choose to which consumer they can extend this benefit. After all, this is a concession, sir.
My lord, I
And
bow-
where do you apply Article 14, etc.? If between two similarly placed persons, right? You have been enjoying a concession, being in the command area. Now the other man says, no, I have to be also. Why you restricted to them? Then they went to the commission, rightly so. Commission has given them liberty. Or you should have questioned this order of the commission, saying that they cannot choose the consumers. And all consumers is, you rightly said, you have said at page number 61, it uses the word all. In several places it's used. But in the notification issued pursuant to the order of the commission.
my lord, with some respect, kindly come to page 60.
All right, it's
But
a,
1 minute.
it's a good question, we'll consider.
My lord, one line, my lord, 69, thereafter, my one line, 61, kindly, my lord, page 61. First 2 lines, my lord. I tendered apology, my lord. As per order dated, this is the notification as per order dated 8th February 2000. My lord, this subsequent notification at page 205 is pursuant to a direction of in 2015. Kindly see 205.
No, correct. You're right.
Well, this
Last
is-
paragraph, but it also says
Well-
the rebates as allowed by order dated 8 to 17 of the Regulatory Commission and notified by WPSC EDL on 10/2 shall not be applicable.
But can they go back to this notification without amending this original notification? But my
No, the notification gives a small window. He can choose who was the
No, no,
consumer.
that he has chosen at page 62. Page 62 he has changed. This is the eligibility of additional rebate.
But, this should have been challenged.
Eligibility of additional rebate.
Or you should have challenged it before the commission as a group of consumers. You could have gone before the commission and said that this notification is not in consonance with that direction.
My lord, I could have, but my lord, subject to correction. My lord.
But you will always have an association, no, of
This
consumers.
This is not an my lord.
No, normally it's
Yes, of
association.
course, they have, my lord. There are several litigations filed, my lord, with.
Because before the commission, because I dealt with this
Lord, I-
tariff order, sitting single as well as in DB. So it is invariably the association
There
which
is an
comes up.
association which is in respect of DVC consumer. In some of the matters, my lord, I have the opportunity to oppose today that Mr. Dotto had mentioned a matter where Mr. Mukherjee duty matter, when Mr. Mukherjee is opposing me. So in more or less for all the DVC matters.
My lord,
No, it's actually should be a collective contest.
My lord, difficulty is this is a singular. But WBCDL I have not come across there is an association. DVC, all of them are because they are
No,
industrial.
you can have Steel Manufacturers Association, whatever it is you
My
can.
lord, arc furnace, my lord, arc
Arc
furnace.
furnace. But
They
the
are the
only
right-
thing is, what he says is, considering that the benefit will come through, he has stepped up his production.
My lord, it's
capacity.
happened, my lord. My lord, these orders of the, my lord, of the commission and government which are referred to, my lord, relate to permission being taken from the state government for implementing. My lord, those were the directions. On pursuant to that, the
Now, if,
notification.
refund has also been ordered.
Yes, my lord, but we have not
That we
claimed
paid. My lord, that has been adjusted. That is with regard to the competitive
October,
tariffs.
from
So,
October.
yes, my lord, we have.
But my lord, there was a direction that we should go and claim that money. We have not done that because my lord,
Where is that direction?
My lord, kindly take, my lord, the order, my lord, in my lord, at para 42, my lord, kindly come to para 40. My lord, at page 9, my lord, insofar as the quantification of financial loss suffered by petitioner for not getting the benefit of 2015 scheme to the tune of a charge showing corresponding in the form of difference, and 2015 is the competitive tariff scheme. That's DVC command area, my lord, where there are multiple, my lord, distribution. There being nothing to controvert the veracity or to refund such excess, etc., in not extending the benefit of 215.
Direction is page para 43.
Yes, my lord.
All right, we have heard the learned Advocate General appearing for the appellant and Mr. So-and-so learned. The writ petition, which was filed in the year 2017, has been allowed by the impugned order dated to 23/12/2022. Insofar as the concession which was to be extended to the writ petitioner, concessional tariff to be extended to the writ petitioner from October 2015 has already been complied with by the appellant. The issue which needs to be considered is as to whether the benefit of the rebate, the benefit of the competitive rates as notified in the notification dated 8/5/2017.
No, that's not competitive. That's, my lord, a revenue enhancement scheme. Competitive rates is the 2015 scheme.
The benefit of, so please take that out, the benefit of the revenue enhancement scheme as notified by the appellant in the notification dated 8/5/17 would be applicable to the respondent. The appellant's contention is that in the notification dated 8/5/17, it had been clearly mentioned that the rebates as allowed by the order dated 8/2/17 by the West Bengal Electricity Regulatory Commission and notified by the appellant on 10/2/2017 shall not be applicable for the consumers availing competitive tariff. It is therefore submitted that the learned single bench committed an error in issuing directions as contained in paragraph 43 and 44 of the impugned order. The learned advocate appearing for the respondent writ petitioner, on the other hand, submitted that the notification dated 8/5/2017 has been issued with the consent of the government of West Bengal dated 23/9/2015 and in view of the direction of the Electricity Regulatory Commission wide letter dated 25/7/2014 and not in terms of the order passed by the commission dated 8/2/2017. Further, it is submitted that the scheme for revenue enhancement as notified on 10/2/2017 has been made applicable to all 33 and 132 kV industrial consumers and not extending the benefit of the said scheme to the respondent writ petitioner was discriminatory. One more issue which may be required to be considered is whether the respondent writ petitioner ought to have approached the West Bengal Electricity Regulatory Commission for necessary relief? And was the writ petition maintainable? This question can be considered when the appeal is heard. Since the appeal itself has to be heard till date, the respondent writ petitioner has not made any claim to implement the directions issued by the learned single bench in paragraph 43 and 44 of the impugned order, the directions contained in those paragraphs shall remain stayed till the appeal is heard and disposed of. The appellant has filed an application in Can 2 of 2023, correct?
Yes, my lord.
To bring on record certain additional evidence / documents. The learned advocate appearing for the respondent writ petitioner seeks leave to file their affidavit in opposition to the said application. Full stop. The appeal stands admitted and let affidavit in opposition be filed in Can 2 of 2023 and the prayer sought for in the said application will be considered when the appeal is heard. Let the appeal be listed, included in the combined monthly list of August 2020.
May I pray for one thing? 205, which is the notification my learned senior friend relied upon. Let the licensee produce the gazetted notification. Let them produce that. 205 is the advertisement. Notification, my lord knows, is defined under the Electricity Act.
No, obviously without that they won't, because I don't know whether you have done. Even when the company code authorizes you to publish notice, they will ask for a copy of the order. Newspapers, without that, they will not.
It is there in the original notification.
Definitely it will be there. And one more thing is government notifications, there should be a presumption that everything is done properly. And without enclosing that, they will not. They will not do it.
I'm grateful.
What happened? Item 7 and 8.
6 and 7.
6 and 7.
6 and 7.
What is the
They have 5.
6 and 7. Lord, I had the notes in that matter, my lord. Item 4, my lord.
That is
Item 4, I have already submitted my note by junior as well. Only one thing,
4 is on.
I have add one judgment, which was not cited.
You give the copy.
I have given, and I have beyond the prayer some guidelines I have suggested. That's
all right. You make it. And what is this? Inquiry was done.
Yes, वो in Shamal Mandal और वो दो.
Item 4A, it has to give me judgment.
We directed
to file a report.
Yes, you got a copy of that report. Yesterday.
I have gone through the report.
And what more do you want us to do? Election petition. It can't be served.
I tell you, just 2-3 lines. I'll not waste your lordship's. Kindly see the report. I'll refer to only one paragraph of your lordship's judgment. Your lordship says, I am not reading, that on 15th, your lordship passing the judgment, observing that 17th is the date of withdrawal, which is a crucial date.
Yes.
That your lordship has observed. Now, we have made complaint at night. Kindly see the last page of the report. First report and last report, last page. This was my allegation that I have sent message in WhatsApp that people has ground us, threatening us to withdraw. Now, this is the reply. Verbally communicated for redressal. And one consequent is withdrawal. Now, when the nomination is withdrawn, there is no scope for election petition. At my instance, the election petition scope of petition is very limited. Now, kindly see the first page of the report. First, second, third, The sentence starts from it may be stated the team of the officer visited the office of PRO, BDO Diamond Harbour at so time. All the petitioners, namely so, were contacted over phone for providing them opportunity of being heard. The petitioners were heard. None of the petitioners were not called at the BDO office. They were called over phone, WhatsApp call, whenever, sorry, I'm not voice call, whenever I instructed my client to record it. We tried to record it, they disconnected it. Then they have called through WhatsApp. Now we have recorded in other device. We have said that we are forced to. The situation we have explained, one of them. Nothing is reflecting that. Now let kindly see.
But you could have refused to withdraw.
This is not the situation. This is not the ground.
So you could have gone to the police station.
Let at 11:30 at night, the people are creating pressure. We don't have faith on police because they are informing these goons. That is my allegation. That's the ground reality I cannot avoid. In other matter, the single judge has recorded the two names of this area. We know that they are the dawn of that area. It's not possible. This is practically not possible. And then your rush was.
But the inquiry team, if you see, they are all in the position of secretary, correctional administration, special commissioner.
They have not talked to us.
Have they not talked to them?
They have not talked to us. The BDO has called us over phone. 30-second call. And they have disconnected. Have you filed a writ petition? Yes.
But it says that the petitioners were heard.
That's the point. My point. This is incorrect statement. Let them put it on affidavit. When there must be some CCTV footage in the BDO office. Let them produce the CCTV footage that I was there.
I am in possession of two.
Before the court, they must come up with some facts which is true.
But the issue is what to be, how can this be decided in a writ petition?
Writ petition I have come because I have no alternative remedy. But the last page of the report.
But the team of officers which are constituted, they would have heard the petitioners, at least one of them.
Your Lordship, may I come back again on this?
The report doesn't say so.
I will ask.
Very
what
cleverly
exactly-
drafted.
Next time onwards, you ask somebody to sign the report with the seal.
But somebody has nobody has signed.
Second page only signature is there. That is
Video.
all right. Pass over. Next.
Same.
इसको रख दो.
6 and 7 pass over.
Current type bola diyeche.
We'll come.
Extremely sorry, I was talking in other matter.
No problem. We'll come back in 10 minutes.
इसको रख दो.
Yes.
Serial number 11.
Yes.
My lord, I appear on behalf of the respondent number 1.
Appellant.
But, the state is the appellant, my lord. But the order impugned, my lord, is at page 108. Lord,
Nobody appears for the state.
Lord, pursuant to my lord, the scheme floated, my lord, Green City Mission Project, my lord, all my lord street lights, my lord, were converted, my lord, to LEDs. My lord, work orders were issued by the municipality. My lord, we had performed. My lord, there is an admission, my lord, that on their part by the municipality that sums are payable. My lord, the writ petition was allowed.
They have not implemented the order, filed an appeal. You have filed a contempt.
We have filed a contempt.
None appears for the state, appellant state, adjourned by 2 weeks. You proceed with the contempt. Next.
My lord will kindly indicate, my lord, I am entitled to proceed.
Not today, and they are not present.
Very well.
In their
Right.
presence, we can.
I'll come.
Next.
Serial number 12.
दाखवा नहीं 11 टा item number 11 your lordships
11
but I appear for the appellant
adjourned. None appears for the appellant. I will say not today. Not today. Item 12. Next.
Serial number 13.
I am for the appellant.
I am for respondent number 3 meter
Respond. You are the contesting respondent.
Howrah Minister Corporation.
May I say, my lord, that the service made to the my lord writ petitioner, my lord, has been returned, my lord, with remarks, my lord, that address is left without instructions. Though it was served on the address given in the writ petition, my lord.
Then we will give you liberty to serve the advocate who appeared.
Yes, my lord, because we have tried to serve, but they have not received since, my lord, no wakalatnama, my lord. They said that they had power to only appear in the writ petition. As such, they refused, my lord. I have directly. Very well, my lord, I can serve, my lord. My lord. Only thing, my lord, why I have mentioned this matter, my lord, by the order impugned, my lord, the learned single judge, my lord, while setting aside an order, my lord, passed by the chief electrical inspector, my lord, has said that the corporation would demolish the, my lord, lift in question, my lord. And my lord, I have instructions, my lord. The corporation is also here, my lord, that they can demolish it at any time. That's the, my lord.
But
and this order was passed, my lord, by a
That is an unauthorized structure. We have to demolish.
by a bench having determination of group 9. And this comes under the determination of group 5. So this order was, my lord, totally.
doesn't matter. What you can't plead equity when you are not acted in equity.
No, my lord, may I
It is
say,
an
my lord,
unauthorized construction. They are
that
entitled.
those demolition notices are under challenge in a writ petition. And this learned single judge, my lord, in the previous round of litigation itself, my lord, said that this would abide by the decision of that other writ petition, which is still pending, my lord.
So you should have asked either to club the writ petitions or to say, let the group 5 be heard along with this.
But the writ petitioners were
But
different.
if it is a fact that it is an unauthorized construction,
my lord,
or illegal construction, then what else can be done?
May I say, my lord, it's only
No,
about.
please tell on that. How do you say it is not an illegal
Lord,
construction?
Lord, they have, my lord, complained before the chief electrical inspector that I have, my lord, made a lift, my lord, without taking permission. My lord, they have come up, my lord, before this honorable court, my lord, and my lord, an order was passed, my lord, that is at page 68, where, my lord, the chief electrical inspector itself said that they do not have power to go into this issue.
It is no positive. In view of the above observation, it is expected that the Howrah Municipal Corporation shall take immediate urgent steps for carrying on the demolition work in in due process of law
One thing.
pursuant to the notices.
Now, my lord, these
No,
notices,
those demolition notices, there is no stay. You move for stay.
my lord, I'll say, my lord.
You move for stay in that writ petition.
My lord, may I say, my lord, that writ petition when moved was firstly allowed, my lord, saying to demolish. That order was challenged, my lord, before the division bench. Division bench was of the view that I should have given an opportunity to file affidavit and the matter should be heard on merits. But I have filed, my lord, also. And that writ petition is pending for hearing, my lord, before that bench.
Before the division bench.
No, before the single bench. The division bench has set aside the order of the single bench.
So you seek for fresh interim orders in
But
that.
I am, my lord, since, my lord, the bench is, my lord,
we will give you liberty. What is that writ petition number?
So far as unauthorized construction is there, my lord, I am
And so, sir,
suggesting only
He says
that they should break demolish that lift, that structure, and they should apply again for a plan regarding that structure.
all right. What is that?
That they can do, my.
Writ petition number.
the writ petition number is, my lord,
Where is the order?
my lord, WP 15143 of 20.
Order,
My lord, may I
page.
say, my lord, kindly see once, my lord, page 68, my lord. This was the order, my lord, passed in the first writ petition, my lord, filed by this writ petitioner.
No, you said there is a division bench order.
Yes, my lord.
It
That
said-
order, my lord, is at page 88. Page 90 is the, my lord, relevant portions. My lord.
We remand the matter back to having determination so and so. So you move for an interim order in that, we'll give you liberty.
Since motion stage, my lord, has already gone and, my lord, it's pending
No,
for
you can
hearing.
file an application. You file a application and it will be listed. This MAT
But may-
1896 of
My lord.
2022
My lord.
is against the order, an order in WP 15143 of.
No, my lord. 4013 of, I'm sorry, my lord. Yes, my lord. 15143 of 2020.
Now that has been restored
Yes.
to be heard.
Yes, my lord.
Matter is pending.
Yes, my lord.
Please come. This
May I-
intra-court appeal by the
May I only
petitioner.
indicate, my lord? My lord,
Hear this order. This intra-court appeal is directed against the order dated 17/4/2023, by which an observation / direction, observation has been made by the learned single bench by
one thing, my lord.
stating that it is expected that the Howrah Municipal Corporation shall take immediate and urgent steps for carrying out the demolition work in due process of law pursuant to the demolition notices issued by the corporation in respect of the elevator in question. The learned advocate appearing for the appellant pointed out that there was a writ petition filed by the appellant in WPA 15143 of 2022, wherein the notices issued by the Howrah Municipal Corporation for demolition of the lift in question was put to challenge. And that writ petition was disposed of by order dated 14th November 2022, against which an intra-court appeal was filed in MAT number 1896 of 2022, which was disposed of by order dated 13/12/2022, setting aside the order passed in the writ petition and remanding the matter back to the learned single bench to hear the writ petition afresh after exchange of affidavits. The apprehension of the appellant is that pursuant to the observations made in the impugned order, the Howrah Municipal Corporation will take immediate steps to demolish the elevator in question. We find that there is no positive direction for demolition, and the court has observed that the matter has to be action has to be carried out after following due process of law. Therefore, if the appellant apprehends any demolition without following due process of law, nothing prevents the appellant for filing a fresh application for stay or injunction in WPA 15143 of 2022. In the light of the above, The appeal stands disposed of by giving liberty to the appellant to file a fresh application for stay/injunction in WPA 15143 of 2022. And if such application is filed, the same shall be listed before the concerned honorable single bench, having determination under the caption applications.
Till that time, if my lord kindly grants me, my lord.
Next.
My lord, one thing, my lord.
I may also, my lord, add, my lord,
Yep.
there is another appeal filed by the chief electrical inspector, my lord, against the same order. My lord.
Let that come, 50,000 cost against that order. Against the cost.
Yes, my lord.
Let it
Only
come.
one indulgence, my lord. They have probably served it to the corporation. But so far as my case is concerned, they let them give a copy of the.
My lord has not granted me stay only because, my lord, there was an observation that they will in due process of law. We have received notices from them that they will demolish, my lord.
You file an application tomorrow.
I'll do it, my lord. Kindly protect me for, my lord, a limited time, my lord.
It is only an observation, not a direction. Next.
Serial number 14.
I am appealing for the petitioner. Appellant. I am filing my affidavit of service.
Yes.
Well, I appear for the respondent WBC receiver.
The dispute relates to removal of electricity lines, my lord.
Overhead line.
Well,
Overhead line.
Overhead lines. Well, my contention was very simple, that the expenses has to be borne by the distribution company. Well, interpreting section 17 of the Telegraph Act, which is applicable, my lord, I have said, my lord, the language is very clear. If you have paid me compensation, till 50% of that compensation, I am liable to bear. Consequently, although not written in the law, my lord, if you have not paid any compensation to me, then you have to bear the full cost. They are ready to remove the line, but only dispute is in relation to the compensation. Whether the honorable single bench has interpreted it that since I have not got any compensation, that will not apply to me. That bar will not apply to me. My interpretation is very simple, madam. If the language of section 17 says that 50%, the compensation is limited to 50%, then, my lord, it means if I have not been given any compensation, you have to bear the whole cost.
But
kindly see section 17, it is quoted in paragraph 16 of the.
Yes, page 5.
Page 5, paragraph 16. Removal or alteration. When under the foregoing provisions of this act, a telegraph line or post has been placed by the telegraph authority under, over, along, across, in or upon a property, not being the property vested in under the control of the management of a local authority, and any person, will kindly pay to the nature of the language. Any person entitled to do so desires to deal with the property in such a manner as to render it necessary or convenient that the telegraph line or post should be removed to another part thereof, or to a higher or lower level, or altered in form. He may require the telegraph authority to remove or alter the line or post accordingly, provided that if compensation has been paid under section 10 clause D, he shall, when making the requisition, tender to the telegraph authority the amount requisite to defray the expense of the removal or alteration, or half of the amount as paid as compensation, whichever may be smaller. It is very clear. So if you have not paid me any compensation, you have to bear the full compensation.
Full expense.
Full expenses. And also there is another part, my lord, will kindly see the last 2-3 lines of the first of subsection 1. Render it necessary or convenient that the telegraph line or post should be removed to another part thereof, or to a higher or lower level, or altered in form. Well, it means, my lord, it does not mean that the telegraph line can be only removed in that line. That is what has been interpreted by the honorable single judge, that it can only be moved to the in the same plot, my lord, not to other property, but the section does not say that. My lord, kindly see 19, my lord, paragraph 19. The expression or to a higher or lower level or.
If you see the section, removal or alteration of telegraph line or post on property other than that of local authority.
My lord, this is that is not the issue here. It is not, local authority is not involved. Private property, my lord.
Now the line is passing over the petitioner's property. Now you want to shift it outside your limits of your
Outside, it may be raised, it is up to them. I am not able to construct a building there because of presence of the overhead lines. It is for them to, they have not said it is impossible to remove. They have said it is possible, but they have raised the demand.
They have raised the full demand or
full demand? Full demand. They have raised the full demand. And the fact is that they have not paid a compensation. And my case is not whether I should get a compensation or not. That.
What is section 10?
Section 10 is compensation.
But his application under section 10 is at page 57.
Well, let's see. May Telegraph Act. Well, power for telegraph authority to place, maintain, etc. Okay. Well, this is in respect to provided telegraph authority shall not exercise.
Clause D. In exercise of the powers conferred with section, telegraph authority shall do as little damage as possible when it's been excised by the powers on any property other than referred to clause. Shall pay full compensation to all persons interested for any damage sustained by them by reason of the exercise of those powers. So admittedly, no claim was made, no compensation paid.
I am not saying give me compensation.
No, he has made a claim. He made a claim at 57, made an application, and which was duly considered by the district magistrate.
No. My lord, section powers under section 10 and section 11 are absolutely separate. I cannot make a demand for compensation under section 11. This is the third round of litigation, my lord. They cannot now say, oh, you have made since you have made a compensation claim, I may have written, my lord. Compensation. I don't think I made any claim for compensation. That issue is being raised only to
No, he has not made a claim for compensation. What he says is, I have not been paid any compensation. And the line is going above my head, above my property. So you please shift the line. So in that if you have not obtained consent from him prior to drawing the line, if he refused consent, you could have compensated him, or if he had objected.
My lord, this is not a case, stray case that the line has been drawn over his property. This was done under a scheme, and my lord, the huge line has been drawn over hundred of the
relevant facts. These are not relevant. Relevant fact is that it can be removed today. They have agreed to remove it. Whether I should bear the cost or they should bear the cost. This is very limited scope of.
No compensation has been paid. It is you who have to bear the cost. Huh? If no compensation,
language is very clear.
That is why the learned there is some order which was passed on 2nd March 2021, wherein it was said produce necessary papers to show that the consent of the petitioner has been taken by the respondent distribution company and compensation, if any, has been paid.
This was the first.
If he has not paid any compensation, and if it is feasible of shifting, you shift at your cost.
Lordship, that part is, may not observe, Lordship, kindly come to page 62, how the district magistrate has dealt with the issue. Kindly come to this. page 62, Lordship.
Yes.
My lord, pursuant to the order of this honorable court, my lord, the testimony took up the matter. Now, my lord, I am just placing, my lord, the audited 26/9/22. That's my lord, the last portion of 62. The WBCTCL authority is represented by assistant engineer, technical Gauria division, remained present, and the attendance is taken on record. The petitioner Pradipta Mukherjee remained present along with his advocate appointed by legal aid, and their attendance are taken on record. And in the year 2011, and mutated his name in LR record number such and such. And it at the time of the purchase of the said plot, there was no high tension electric wire over his plot of land. In the year 2017, when the petitioner took steps for construction of a house on the aforesaid land, he came to know that WBCTCL has drawn a high tension wire over the land. On 12/10/17, the petitioner wrote to the WBCTCL calling upon them to remove the high tension wire over the said land since he faced difficulty in constructing a house due to the presence of the high tension wire. On 13/10/18, WBCTCL asked him to deposit a sum of rupees 1,57,887.33 only by way of demand draft in favor of WBCTCL for removal of the aforesaid electric line and high tension line from the said land. The petitioner thereafter filed a writ petition for being the W number such and such before the Honorable High Court at Calcutta. Pursuant to the solemn order passed by the Honorable High Court in the aforesaid writ petition, a hearing was held before the Divisional Engineer Electrical and Divisional Manager Gauria Division, being the reference number 4 on 7/4/21. By an order dated 3/5/21, the said respondent ordered that the petitioner may again approach WBCTCL for issuance of the fresh quotation for shifting of the said high tension line as per norms of the distribution company. On 17/2/22, the petitioner submitted an application under section 17(2) of the Telegraph Act before the learned district magistrate and praying for a direction upon the WBCTCL for removal or alteration of the high tension wire over the petitioner land. Since no remedy have been received from this end, the writ petition has been filed. As such, it is necessary to find out the clear picture of the condition of the present site in the premises for the petitioner Sri Pradipta Mukherjee. Before adjudication on the matter, the Assistant Engineer Technical Gauria Division is directed to undertake exhaustive field inquiry in presence of the petitioner BL and LRO Sonarpur, officer in charge of the Sonarpur PS, and submitted report to the end specifying whether any shifting, removal, high tension where is possible. The inspection report is to be submitted before next date of hearing. The matter is adjourned. Now, my lord, next. The case record
He's just reading, he's not making.
Ultimately,
I am coming to the finding, my lord, then my lord.
ultimately, the district magistrate says that you revise the quotation amount.
My lord,
Because he's a poor
at page
person, you-
65, my lord, the last paragraph of this order, my lord, at page 65, my lord. Kindly come, I am just reading the paragraph, my lord. The WBSCDCL authority stated that the line had been drawn for public purpose as the provision underlined under section 164 of the Electricity Act 2003 and Indian Telegraph Act 1885. Any shifting cost needs to be borne by the petitioner. The learned advocate representing WBSCDCL cited judgment dated 26th of April 2022 passed by Honorable Chief Justice Prakash Srivastava and Honorable Justice Rashid Bhardwaj of the High Court at Calcutta in
Where
FMA.
is the judgment?
This issue has not
My
at
lord.
all been discussed there, my lord. Maybe I.
My lord, I have the
Payment
soft
is-
copy, my lord, unfortunately, my lord.
This issue was not
Sir,
discussed.
it has been found to be technically feasible.
Technically feasible. it is.
Second is admittedly no compensation paid.
But the compensation part has to determine how much land is at all. If at all land is encroached upon or not, that
But
requires
fact is,
inquiry.
it has not been determined.
No, no.
Fact is, it has not been determined.
Not in your
Compensation has
case.
not been paid. And how do you say that this 1 lakh and odd he has to pay for shifting? You have drawn the line. Of course, the district magistrate says at the time when the line was drawn and energized, it was an agricultural line.
Overall, I mean, it's not a milord, it's a very small area.
Land,
A huge line.
33 kV.
33 kV for about milord 11 kilometers.
Fine.
And milord,
But you have said it is feasible to shift.
that we are not denying, lordship. But only thing is this,
But how
if
will
milord all the cultivators now come and say, my lord, all this our land is also encroached upon and high tension line for the development to work and
Then,
for
my
the
lord-
public interest.
Then, my lord,
has been done.
you challenge the validity of this section, my lord.
No, that is different issue.
It
But
cannot be
after, my lord,
interpreted away.
after, my lord, 10 years of drawal of the line, because in 2011, it has been done.
My lord,
Where
may I
the-
show the judgment, my lord, para 4, my lord, the relevant, my lord. Passed by the then Chief Justice, my lord.
দেখো তো যে judgment আছে কিনা। এইটা এটা। FMA 336
It deals with the compensation part of it.
এই দেখে তোমার টেলিগ্রাফ একটা কি একটু আছো?
হুম, হুম, হুম। কোন প্যারাগ্রাফটা দেখাল?
Para 4. FMA.
হুম, হুম, হুম। রাজশ্রী ভরদ্বাজ তো?
But the facts were slightly different. here.
Section 70 is not at
Where,
all.
he did not even make a formal application for shifting. That has been done. Writ petition was filed,
Right.
direction issued, district magistrate under 17(2) was directed to consider the matter. And he considered it, recorded the submission of the distribution company, saying it is feasible of shifting. Now, the only issue is whether he should be called upon to pay the amount for shifting. So in the absence of any compensation, maybe it is 3 years, etc. Now we need not reopen whether shifting is because shifting has been found to be feasible.
Ma-
So when he has not received any compensation and now he is not able to put the land to use, then it is the distribution company which has to bear the cost of shifting.
Normally, only issue is, now, my lord, since this is happening, this demand is coming after, my lord, about 10 years. Then, my lord, 100 of cultivators are involved. Because in all this development work, drawal of high tension supply. No, not apprehension. Not
For
apprehension.
10 kilometers.
It's a practical problem.
It's a problem. It's a problem.
It's a
No,
practical.
no. We have.
No, it's a 33 kV line, sir.
I understand, my
Now,
lord.
my lord, this
And you have kept quiet all these years. They drew the line, they energized.
Well, I understand.
and
I fully
100 of
understand
and
fully.
100 of cultivators
My
now
lord,
affected
this-
because their land that time they did not think about construction. Now they may think about construction. When this sort of difference will be coming up, then everybody will come up because we will sell construction. to
Kindly see
remove it.
their argument. Everybody will come up. It is not an argument on the facts of this case.
It is not a
It is
fact.
an argument on
Well,
apprehensions.
It
what
is
will
not a
happen.
fact. It was not notified.
But
It's
you-
under the scheme. System is this, my lord, before enunciation of the same scheme, it is to be advertised. My lord, if there is any objection of the people of the locality who are over whose line to be high tension line to be drawn, they must come forward and make an application before the DM or the concerned SDO or BDO saying that I have objection and this has to be considered. My lord, this is a development scheme enacted in 2011, and my lord,
But then this order passed by the DM has not been questioned by the distribution company.
my lord, it is a DM has said, my lord, it is possible. We have also suggested that it could be done, but who will bear the cost? Because that time you did not put
He
it
has
on.
not received any compensation.
He did not approach, my lord. He did not make an application. We do not. my
Well,
lord, only
had
thing
they
is this,
refused,
the first-
that it cannot be done.
1 second. If somebody doesn't come forward saying that I need compensation because you have encroached my land without intimating me, without any notification, it is not the case. Now, all on a sudden, after 8 years or 10 years, somebody is coming that you'll have to shift it. We have made a survey, thorough survey, it say that this particular shifting is possible, but now you have to bear the cost. That's the issue.
Sir, it is not a individual line. That division bench
I
matter.
understand. Mal- I fully understand
It is
what
a-
the lordship is trying to say.
And after so many years, if you need to shift. And
My lord, so, my lord, again,
And
I am
he is
making the
entitled
same
to
statement.
compensation. Let him, Lord, approach the civil court and
Kindly
Lord,
see, kindly see.
pray for compensation.
Hey, what they are saying is, what their case basically is, if
And
you
at
pay,
our cost, my lord, it's a huge
My
high
lord, kindly
tension
see.
line. Entire alignment may be disturbed. I do not know. My technical engineer has said it might be done. If others come, then obviously that will binding upon us. Then entire alignment will be dispersed.
So
100 consumers are not getting
what they are
electricity.
basically saying-
Industries are there. So if that be the case, if they accept it, then everywhere, anytime, high tension supply, it's not a matter of personal interest. It's a matter of national interest and everybody, public interest is involved. And it is not that somebody wish and way, they will come and they will draw it. There must be a process. There is advertisement, calling, inviting objection from the local people. If it is not done that point of time, now they are trying to reopen it. Now we have made survey, we say it could be done. It is possible. But the cost.
It is not a simple exercise.
My lord, kindly understand. Today,
Suppose you had objected to it
my lord,
4 years back.
my lord, it
Then probably at that time, you did not raise objection because
my lord, these are poor people, my lord. They don't even know, my lord, this is in fact from the State Legal Service Authority matter, my lord. They don't even know what to do in these things. Previously, he had filed a writ petition, he
but
had not even.
on reassessment, what is the amount paid?
Same.
Because the DM has said,
Possibly no reassessment order has been
no,
passed.
please come to page 66.
My lord.
About 10 lines from the top. The divisional engineer technical so-and-so division, assistant engineer directed to reassess the value of quotation amount for shifting the said line. In the event of the failure of revision of quotation, WSO must ensure to maintain mandatory safety measure to prevent the falling of the item over the land of the reposition.
To that extent, I have to take it. Reassessment. If it is not done.
So if it comes to around 25,000, 30,000, you pay.
And
I will
apart
talk to
from
him. I
that,
will talk to him. My lord, this issue requires to be, my lord, public interest will not change the law, my lord. Just because public interest is there, my lord, it will not change the interpretation of the law, my lord. Law is very clear. If you have paid compensation, it is 50%. 50%.
You have missed the bus.
No, my lord. I am not claiming compensation.
No, you should have objected when the line was drawn.
My lord, kindly read the section. Kindly read the section one more.
4 years the line was there, and you have enjoyed the connection through the very same line.
No. It was an agricultural land. I was not enjoying. No, it's an agricultural land.
But
It was converted into a. I wanted to build a house.
Not accepted.
Small
It is an agricultural land, you can use it for agricultural purposes.
I cannot now, my lord. I have sought for.
6.6 meters above
I
ground level.
I have sought for. I already made an application. I want to build a
Have you
house.
obtained the conversion certificate?
Not yet.
No.
So,
No. I have
not yet.
My lord, your lord's question was.
your prayer is that you want to make a construction.
Yes,
How can you make a construction on an agricultural land?
No, it has been converted. That is converted.
Where have you stated that it has been converted?
There is no averment.
No averment.
You
And
take
most
your
lordship
petition.
entered, if that be the, if this is the, this is
Well,
considered right
paragraph
now.
4 of my stay petition. It is
Paragraph 4 of the
my stay petition. Lord.
In the writ petition.
Well, I must have, my lord. Because
Page 20.
my lord, paragraph 5 in my writ petition.
Made in
When
application.
was the line drawn?
In 2011, lordship. In 2011, it is done.
But he has purchased the property only in the year 2011.
Yes.
And but he is fully aware of this, what is happening.
No, your vendor must have been aware.
They could have raised
My lord,
objection.
my lord, let us admit. My lord, let us admit the worst case scenario, my lord. Let us proceed on basis of the worst case scenario, my lord. Will that change the interpretation of the statute or not, my lord?
Land has already been reclassified. BLN LRO has passed an order on 24/12/2020 reclassifying the land.
That is there. But he has not raised an objection, my lord, at the time when the scheme has been, my lord, executed in the area.
In 2011, he purchased the property.
Yes.
At that time, it was an agricultural land, line was drawn. 2020, he has got the land classified as Vastu. 2020, December 2020. So now he has come forward with his application.
And my lord, if that is accepted, I know very well, because we are not, my lord, it is our own interest. Everything is for public interest. Enter high tension supply, my lord.
Application.
And not the entire high tension supply, which is drawn, my lord, everybody says that yes, you see.
If the proviso cannot be applied, then show us from the main provision that he is required to pay these charges as per section 17.
My lord, 17.
Proviso cannot be invoked, compensation has not been paid. So if the proviso cannot be invoked, show us from the main section that he is liable
My
to pay.
humble submission, my lord, compensation has to be paid, means somebody, it will be automatic, or somebody will have to
That is
make
the
an
difference.
application.
The fact remains, the compensation has not been
He has
paid.
not made an application.
Proviso cannot be invoked. Show us from the main provision that he is liable to pay for the shifting.
But my humble submission is this.
Exception, no, sir. Proviso is an exception.
Exception. Now, my lord, only thing
It
is
doesn't
this.
fall within the exception. So the main section doesn't provide for any payment. So you consider and
Lordship, select.
all right. We have heard the parties, judgment reserved. Right.
But Lordship, kindly consider that for 10 years, they were remaining silent, and there is no demand also.
And my simple,
That Mr. Nayak, you did not raise that objection before the learned single judge.
Next.
Maintenance point was not issued, raised before the learned single judge.
But it is also fact, my lord, otherwise everywhere, my lord, that will come up.
6, 7, 8, you run the list, sir. 22. Call.
Serial number
Grateful.
15. Lord, I am for the state response. 15. Well, I am for the petition, my appeal matter. Before my learned senior friend start, my lord, I have an objection regarding grounds number 2. This kind of language should be struck down from the memorandum of appeal. Page 3 of the memorandum of appeal, my lord, grounds number 2, that language should be modified. That should not be used. A case cannot be called as a product. Ground. Let it be expunged from the memorandum of appeal.
You please amend it. Page 3, ground 2. And if it is an authority or some statutory authority, use the expression non-application.
Lord, the leave may be granted to.
We have heard so and so. It is pointed out by the learned advocate for the respondent state that ground number 2 in page 3 of the memorandum of appeal is in bad taste. The learned advocate appearing for the appellant seeks leave to amend the grounds and delete ground number 2. Leave granted. List the matter next week under the same caption. Next.
Serial number 16.
Yes.
I have a petition about mandamus appeal is pending. I'm before your lordship for application for stay. I'm applying before the stay of the application or impugned order as passed in the court below by the Hon'ble court below. It is mandamus appeal is pending. I've prepared and mandamus appeal is pending.
Where is it pending?
before this court. And evidence appeal number 853.
Yes, that's a file.
Yes,
we have.
yes. I am now before your lordship for application for stay.
Now, what is the relief you had sought for in the
Relief
writ
only
petition?
stay of the impugned order. Relief before I am
No. In the writ petition.
writ petition. Writ petition, my lord, I am an octogenarian old father. I am an octogenarian old father.
But how a writ is maintainable for such an issue? If according to the son, the petitioner had gifted the property and the petitioner is.
I'm not withdraw. I'm not on that point because on the behaved by my son against me was all before father. I have very well sheer cruelty. For that reason, I only pray before this court. There are only 400 had before the old father before your lordship. That at least I'm a widower also. I am not no one, only 2 sons. I also expect that sons will be respectful to me. It's this much. Old father,
The second son is taking care of the father.
both I have both sons, first son and second son. First son had on 15th February 23 behaved very rudely, which I very much insulted. I went to my younger son, but when I went to the younger son, first son had stopped looking after.
Who's appearing for the respondent? Have notice has been served?
No. It's first appearance.
All right.
The first appearance.
Let notice be served on the respondents. Within 2 weeks, affidavit of service be filed. List the
In the
matter.
interim order.
Next.
What interim order?
Stay of the order.
Writ petition has been dismissed. What stay you want?
Order. Only I would.
You serve notice. Next.
Serial number 17.
Well, I'm saying one. I will leave people granted to correction on the ground. Only ground number 9.
All right. Leave granted to correct ground number 9. Yes.
Yeah.
In this matter, Mr. Subish Sanal appearing on behalf of the appellant, due to his personal difficulty, he has not come.
Not today.
Serial number 17.
17, we are appearing on behalf of the respondents.
He says personal income.
No objection.
Request not today. Call.
Milord, may I?
18.
Second. I am for the Milord. Second. May I pray one? Milord, instead of not today, would your lordship take up this matter next week, any day?
Wednesday. Next
Will
Wednesday.
come on next Wednesday.
Lordship.
Yes, item 18.
My lord, this is my application, my lord.
Lordship, I am for state.
My lord, here, my lord.
I am for the writ petitioner
My lord,
respondent.
my lord, copy of has been already served, my lord. My lord, here, my lord, I am the, my lord, daughter-in-law of the writ petitioner, my lord. My lord, I was restrained to enter in my matrimonial house where I have been residing for last 9 years, my lord. My lord, kindly see, my lord, after the demise of my father-in-law, my lord, at the instance of my lord, my sister-in-law, the instant writ application was filed. My lord, kindly see the, my lord, the amendments made in the writ application and the complaint against me, my lord. My lord, is this a process to, my lord, evict the daughter-in-law from the matrimonial house, my lord, by way of this, my lord? My lord, now, my lord, admittedly, my
Wait. No notice was served on the appellant. You were heard in the matter.
Yes. Kindly see the order.
my lord,
Page 16.
at the time of initial
Page 16.
moving the writ application, there no copy was served upon me. My lord, since my lord, I was at that relevant point of time when I was at my lord Bengaluru for my treatment of my children, my lord. And since that is why, my lord, I have not received any. I could not.
In your grounds, have you said that you have not been served?
Yes, my lord.
Which show which ground? You have not said so.
No, my lord, in my memo of appeal, my lord.
And the writ petitioner is the appellant's sister-in-law.
No, writ petition is the mother-in-law who has been ousted by them.
No, my lord, it's a
My lord, this issue was placed before the single judge. Single judge scrutinized, FIR was registered, state is here representing. They ousted me, the husband and wife together ousted me from the house.
Now-
I was escorted by the police to enter my house, own house. It's in my name.
False allegation, my lord.
It's in my name, my lord. This
For
is the
last
petition.
9 years, my lord,
He
my
has not served the copy of the
mother-in-law
writ
is
petition
stay,
also.
my lord, my marriage was solemnized prior to my lord 9 years, my lord. I have been residing with my mother-in-law and father-in-law in the said room, my lord, said house, my lord, for last 9 years, my lord. My lord, it is after the demise of my father-in-law, my lord, the facts has been cropped up, my lord, and it is false allegation at the instance of my sister-in-law, my lord. They took my mother-in-law at their house, and my lord,
The order says
Lordship,
that the writ petitioner should be escorted back into her house.
Lordship,
The property is owned by the writ petitioner.
Lordship.
If the daughter-in-law claims that she is entitled to reside there, you go on to the civil court and obtain a house. Both your client's husband and your client, both of them can go.
My lord,
What is your client's husband doing now? He is supporting the mother or supporting your client?
Supporting the wife. Supporting
No, my lord, writ petition,
Waste of time.
appeal is my lord, by the mother, by this daughter-in-law, my lord. My lord,
No, you go and obtain some order from someone.
my lord, I have been, my lord, my lord, kindly see the last order, my lord. Impugned order, my lord. What is the order, my lord?
Sir, if you don't dispute that the property belongs to her, you have no exclusive right to claim.
My lord,
Wait, please. If at all your client's husband says, no, it is not her individual property. It's a joint family property. It was an ancestral property. Her husband can make a claim. This lady cannot do anything.
what happened, my lord? My entire belongings are remain in the.
That you go to the police, you make a request.
Yes.
They will escort you. You take your belongings.
Yes, that was the order.
Or you compromise with
The order
your
itself,
in-law
they have
and live
already
with
My
taken
lord,
in presence of police
my lord,
officer on 7th of June.
My lord,
all-
kindly appreciate one thing, my lord.
Only to satisfy.
For
the
last
only
9
thing
years,
they are
my lord,
filing this appeal.
my lord, for last 9 years, my lord, I am residing in the said
No, where is the order of eviction?
lordship.
Where is the direction to evict you? No, the direction is to escort the writ petitioner back.
No,
to
my lord, kindly see the last order, my lord. The superintendent of police, Raiganj district shall have last order, my lord, dated 27th April, my lord, 2023, my lord. I have been restrained from entering in my room, my lord.
My lord,
In
kindly
the
see the order.
backdrop of the facts and
How can
circumstances.
this order be passed? Removal of articles from the portion of the house?
No, my lord. Kindly see.
Kindly take up paragraph 4. Can this order be passed in a writ
My lord,
petition?
what they have done.
Directing removal of articles of a person from an immovable property.
They have prayed before the. They have prayed.
Shows
before
that
the-
they have prayed for.
They have prayed before the court. Then, ma'am.
Shows that they were in possession of a portion of the immovable property.
No, they were not in a. They
Articles, this finding, recording of this finding shows that they were in possession.
Yes, my lord. Even my lord,
How can an eviction of a person be passed?
You enjoy the
Under
property.
Article
be there.
226.
In a writ petition, we can't order an eviction.
lordship.
Para 4 of the order will be.
now, my
satisfied.
lord, what happened in this case, my lord, kindly consider that they have admitted they have purchased the adjacent house and they are
Maybe
using.
they may have 4 other properties. Is it the law? On that ground, that eviction will be, an eviction
Yes,
order will be
that is
passed by the writ court. Show us.
No, my lord, but the thing is that it is my property. It is my property.
Maybe.
It is my
Maybe.
property.
Maybe. You cannot evict a trespasser even without due process of law.
My lord, we have not evicted them.
Let us assume that their status is that of a trespasser, not better than that. Can you evict a trespasser without due process of law? Police will go and remove all the articles.
This
They have prayed for it, my lord.
intra-court appeal is directed against the order dated 27/4/2023 in WPA 28886 of 2023. The appellant is the daughter-in-law of the writ petitioner and is aggrieved by the said order wherein a positive direction has been issued that the appellants shall remove all their articles and belongings from the house in question, and such removal shall be done in the presence of the writ petitioner and any of her representatives. The Raiganj police station was directed to depute a lady constable to be present at the time of removal of the article. In our considered view, such a direction could not have been issued in a writ petition, and the fact that the appellant was residing in the very same premises is clear from the fact that a direction has been issued to evict the writ petitioner, evict the appellant from the premises. Therefore, we are of the view. Therefore, the order and direction issued by the learned writ court is wholly out beyond the jurisdiction conferred on the court under Article 226 of the Constitution of India. Therefore, the appeal is allowed, and the order dated 27/4/2023 is set aside. We leave it open to the appellant and the respondents to work out their rights before the appropriate forum in accordance with the law. Next.
Serial number 19.
Yes, serial number 9.
I am for the appellant.
Yes.
Lord, I am led by Mr. Aniruddha Chatterjee, my lord. He's online. I am for the respondent. My lord, I beg to appear on behalf of Union of India, my lord.
Well, this matter arises out of the point when the state procurement agency, they regularly procure jute bags from different jute mills. Previously, DGS&D used to procure for them, see the quality and everything. Now government changed their policy and said no, DGS would not. Instead of that, jute commissioners will arrange for that. It was done under Jute Textile Control Order. It's a statutory power was given to them. In exercise of the statutory power, most important thing was Jute Commission to decide what should be the eligibility criteria for the inspectors who will issue the pre-dispatch certificate. Unless the pre-dispatch certificate issued upon examination by the inspector, the goods cannot be dispatched to the state procuring agencies. Now he framed the rules under the Jute Textile Control Order. That is not at page in 2016. You might not kindly see that, and similar. Now, may just indicate that today that it was working all right. On that basis, 5 inspection agencies were enlisted, impaneled, and they were getting orders on the basis of recommendation or preference of the state procuring agencies. Then we learned in 2022, which is now impugned in this case, without any reason, without stating even on affidavit that there is a change, necessity for modification, amendment, by totally diluting the eligibility criteria, totally diluting. We're giving a chart to learn it just side by side. For example, my lord, the first, it was eligibility criteria was must be a laboratory.
Tender has been awarded in favor of the third respondent.
Yes, well, we are now working on this. Okay, work order issued.
Work order has been issued. Work order has been on 2nd of June.
2nd of June. The matter after that order they have issued, let them issue.
Then we'll hear the appeal.
Yes, hear the appeal, Miller. Can we hear the appeal? Because Miller, this is.
But what is the period for which the tender has been granted? I mean, 3 years, is it?
3 years. 3 years.
3 years.
It's for 3 years, my lord.
3 years, right.
So we'll fix it.
And the second ground is my petitioner, he has made the petition telling me he has been disqualified totally. That is also challenge in the petition.
Oh, there are 2 petitions.
No, one, during the pendency of petition,
Oh,
they disqualified. So amendment of petition. So, my lord, disqualification of my petition, my client, he could not be considered, and without considering him, the new person is main listed. That was our case, that this modification, everything was being done to support a private party.
But the amendment application was not allowed by the single.
Allowed, and with the consent of all parties allowed. And it was also heard along with that. They filed affidavit in opposition. Amendment portion, filed affidavit in opposition also. Disqualification and, my lord, it's possible to, my lord, to fix a date early. The paper may appear to be voluminous, but not so really, because of various affidavits only.
This month it is not possible. In August, we can fix something.
The earliest possibility, earliest possible date.
Heard so on. So the appeal is admitted for hearing. Let the appeal be listed in the company in August. Give it. Next.
I was appearing on behalf of respondent number 2.
Yes, sir. You please give your appearance slips. Next.
কবে হলো ডেটটা কবে দিল 10th কবে ডেট
Come up to 23.
9th August.
Serial number 20.
Lordship, kindly add one thing, the subject of whatever is done about the result of the appeal. But there is the appeal.
That's
Kindly add that, will not, that is not.
Sorry.
Great.
Next. Copy Ragdan has also given a date.
Yes. Good afternoon.
9th of. The filing of paper book may be dispensed with.
All right.
We have filed the paper book.
Paper book dispensed.
And notice of appeal also dispensed with. Notice of appeal dispensed.
Notice of appeal also dispensed. Yes. Item 20,
yes, I am appearing for the respondent.
appellant. Not today. None appears for the appellant.
Serial number 21.
But I appear for the writ petitioner respondent.
Affidavit of service. By the impugned order, my lord, the Honorable First Court has permitted the writ petitioner to erect the boundary wall, my lord, causing serious impediment to my ingress and egress to my property, my lord, and my lord, directed me to file a separate civil suit, although it is a pure civil dispute between the petitioner and the private respondent, my lord. My lord, if due to this observation, even if I file a civil suit, my lord, I will not get any order
Now
from.
they have constructed the compound wall.
Yes, my lord, that they took adjournment, and by that time, my lord, they have, my lord, the erected the.
I tell you,
But
Lordship,
how a writ petition was maintained?
but I tell you, Lordship, my lord, he is not agitating a right of easement. He purchased the property in 2020. There's a deed.
He didn't come to court. You came.
I came to court. I am the owner of the land. He says that he wants to walk through my land. So, my lord, if he wants to enjoy a right of easement, there has to be a continuous use. He purchased the property in 2020.
Proved in a
Lord,
civil suit.
Lord, I am in possession of the property. He doesn't say that he is in possession. He says that he is walking through. There is no dispute with regard to
The
ownership.
right of that easement,
Lord, that,
how can you prevent that by
Lord, that-
constructing a
Lord,
boundary
the
wall?
law says the easement right will only come after 20 years of usage. He has
It
purchased
has
it
to
in,
be decided, Mr. Chakravarti.
Lord, from the document, he's purchased it in 2020.
No, but how is such a writ maintainable? Take
Lord,
immediate steps to set up police picket. For what purpose?
Lord, for,
To complete the boundary wall.
Lord, I tell you, Lordship, there was a boundary wall which has fallen down due to a Amphan.
That
Lord,
does
there was
not
a,
appear from the recording in the order.
yes, I'll show you, Lordship.
No,
There
no,
are
no.
documents.
No, you file your affidavit letter.
Very well, I shall file my affidavit.
We have heard so and so. On going through the order impugned in this appeal, prima facie we find that the matter is purely a civil dispute, and the learned writ court has issued a positive direction permitting the writ petitioner to construct a boundary wall, and also directed police picket to be considered in accordance with the law. We find that we prima facie find there's a clear outreach in the matter, since the dispute is of civil nature. Therefore, the order impugned shall remain stayed till the disposal of the appeal.
But all,
Let the affidavits be filed so and so.
but already, my lord, they have constructed the.
That's all we can do. You've taken application. Next,
Serial number 22.
Yes,
22.
Yes, this writ petitions, my lord, has been filed, my lord,
Yes.
against the refusal of injunctions, my lord, against the encashment of bank guarantee, my lord. That the brief facts, my lords, leading to file this appeal is short is this, my lord, that the Ministry of Power, my lord, that the Damodar Valley
But
Court.
who will appear for the respondents?
My lord, I have served, my lord, lordship's directions, my lord.
But who appeared in the writ petition for?
I have
Yes,
served.
my lord, yes, sir, on the learned advocate, my lord, that
He is not here today.
notice was given.
But it is beyond 1:15. That's why
Yes.
he is not there.
So
He can't,
then tomorrow at the top,
not tomorrow, this bench will not be there.
And
We'll say not today.
uh,
We have heard so and so.
my lord, then Wednesday at the
None
top, my
appears
lord,
for the
because extreme urgency is involved, because
Not today.
let it be, my lord, at the top, because
Same position.
same position. I'm grateful to your lord.
Next.
Serial number 23.
ওটা দেবেন না এটা
All right, not today.
দেবেন
You are going to call.
দাদা এপিডিবিটা
Appellate sites, supplementary list, serial number 1.
24 নয় তো এটা মেনশন করেছিল।
Very short point, my lord. Should be at the right side, my lord, at least. My lord, tender for my lord, tender for sale of a decommissioned thermal power plant by Damodar Valley Corporation. Well, and the e-auction, my lord, the entire process was being conducted by the respondent number 2 is M Junction. So, well, the advertisement is published, well, pursuant to which, well, all interested bidders were required to upload the relevant documents. My lord, one such document, which is the subject matter here now in the present appeal and the writ petition, was something called the Integrity Pact. It's a format document in terms of the my lord, Central Vigilance Commission guideline. You were required to sign it and upload it. My lord, there were 7 documents which we were required to upload. So, well, this uploading, we did it on the 20th of May. So, my lord, uploading is not in my hand. So, my lord, based on whatever is available internet, I upload all the documents. I upload the Integrity Pact as well. So, my lord, now the last date for deposit of earnest money to participate in the auction was the 5th of July. That was yesterday. So, my lord, on the 3rd of July, my lord, in the evening on the 3rd of July, we received a mail, my lord, which was the subject matter of the writ petition, by which I was disqualified. My lord, I'll just trouble your lordship with that mail once.
But admittedly, the document could not be uploaded.
Uploaded.
Deleted.
No, uploaded on 20th May, much before the last date of submission. What they say is, well, I'll show you, not in totality. So, my lord, there was some problem in the uploading. Then, when the matter came up for consideration, there was no, this was the reason given was are not uploaded in totality was the exact reason. Non-submission of Integrity Pact in totality was the reason. When the matter came up before the writ court, the learned judge asked what was the reason. So, my lord, the learned counsel appearing on behalf of DVC handed over to the court, which is now a part of the record now. My lord, this was a 6-page document, the pact. 2 pages had gone blank. So, the uploading which happened, 2 pages apparently went blank. So, we annexed that as well. Now, my lord, for non-furnishing of this 2-page blank, the uploading part, I have been disqualified. So, I cannot participate in the tender. So, my lord, we said, that this was not a mistake.
But does the bid document provide for any correction of any technical error?
No, my lord, technical error, my lord, this is, I say.
Suppose,
I'll
assuming
complete.
there is some connectivity issue.
Yes, my lord.
And you are in the process of being uploaded.
My lord.
50% is being uploaded.
My lord.
The remaining gets
Does not.
junked.
Now, here,
No,
my lord.
what does see, the problem is the scope of interference, like we cannot say that he is the tender inviting authority.
Correct.
We cannot, the grid court cannot dictate to him, no, you amend this NIT in, what is it, notice inviting tender to be in such a format. It is up to him to choose. But if, and there were cases where not so essential conditions.
My lord.
There was one line of judgments earlier which says not so essential, so you can do it, you can accept the hard copies. Then Supreme Court said, no, it's not of your business. It's not for the writ court to say which is essential, which is not essential.
Right.
But the integrity pact is a very, very vital document.
No, my lord, integrity pact, the fact that I uploaded the integrity pact, that is not in dispute. My lord, what has happened is it was not uploaded in totality. This is what they say. So what I say, I annex it to the writ petition.
Where is that document which says it is uploaded in part?
My lord, your lordship will kindly see that is the order of rejection at page 203. My lord, kindly see the reasons for
Totality.
in totality. Now what has happened? Now what happened? Now, my lord, kindly appreciate one thing. I have no occasion to rectify because unless I get a message that document not uploaded entirely, like I file a petition in court.
That is why we asked you whether the tender document provides for any such, gives any such window. In the
If your
absence
lordship-
of it, it is gone. Gone is gone.
Now, my lord, look at the unreasonableness. Then we say that not that I have
Alright.
not given
How
it.
is the writ petition maintainable?
My lord, DVC Damodar Valley Corporation,
Ah,
Government of
yes.
India undertaking.
And this is purely in a private realm, merely
So why,
because-
my lord, your lordship will consider today, why, my lord,
I-
today,
assuming DVC is a private organization, whether the writ is maintainable.
no, my lord,
Can a civil
private,
court say, no, you change your conditions?
no,
This-
I am not on, I say that I have fulfilled the condition. I have said, my lord, kindly appreciate that. I have fulfilled the
But
condition.
if
They say,
it is as good as,
yes,
suppose you file an appeal
my lord,
and it is not affirmed,
my lord.
court fee not remitted.
My lord.
It's no appeal in the eye of law.
My lord, what, may I just, I will just, my lord, my lord,
So if-
allow me to, my lord, address your lordship on that. I file an appeal. In the stay application, my lord, I annex a document. Several documents are in order.
this
I
appeal
annex
is-
a document, 2
we
pages
shouldn't
of
be
the
seeing
relevant
this.
documents are not there.
we shouldn't be seeing this. It's not affirmed.
My lord, kindly appreciate, my lord, today your lordship will see, I have not been able to participate.
We
So,
will
my lord,
ask,
what, my lord,
But
today
how-
this is
how
a sale. It is not a performance-based tender. It is a sale. It is a sale of, so my lord, if
That's
today the bid price goes up, will it not inure to the benefit of the public at large?
If the portal gets locked, thereafter, there's no opportunity for you to.
No, what I have done is, my lord, I had to give the EMD. There's something called the wallet, as your lordship knows. I have put the money 9.5 crores in the wallet within the time. So the money is there in the wallet. All I have left to do is that allow me to participate. It is there going on. The auction is still there till 8 PM. Auction is in process. Auction is there till 8 PM.
No,
That's
if
all
it
that
is
I
a fact that part of the document was uploaded.
Let me show your lordship what was uploaded and what was not uploaded. Lord, please come to Lord page 211.
Faulty appeal.
211,
Yes,
the heading is Integrity Pact.
yes.
This is uploaded. Lord, please turn the pages over. 213 blank. 212, 213 blank. 2 pages blank. Now, Lord, please see what are the clauses, because each page has to be signed as their commitment that they will confirm with this integrity pact and the terms of
No,
this.
we dealt with the matter concerning the integrity pact.
Now, this includes corruption. This includes, Lord, ensuring that earlier on no other company has disqualified them.
Yes.
And Lord, please, Lord, today, Lord, 17 bidders had participated. Of the 17 bidders, Lord, 12 qualified in this bid. We have rejected 3 on the ground of integrity pact.
One
If
among
this
the-
person gets in through the back door, then the entire tendering process will have to be scrapped.
How?
11 bidders have submitted the earnest money of 9.45 crore each. The entire process will become completely infructuous. And when we start again, if there's a litigation, we will not get bidders anymore.
But the integrity pact is a very vital document. In
Look,
fact,
I take your lordship
the
to the
second page, there will be,
No,
we have seen the
I
earlier.
had given it in the writ petition. The fact, the entire integrity
Lord,
pact.
we
what
can't
they,
as a
what
Well,
they
I tell
say
you,
is
lordship.
that later on we have sent a mail. We are not allowed to open the mail. We can only see what is uploaded by M Junction on in M Junction's website. We are not allowed to give a
And there is
different
no
opening to
other-
anybody else.
There is no other
Opening to anybody else.
There is no other avenue for you to remedy the breach.
No, but if your lordship will see, that's if it is considered to be a breach,
Speaking on common terms,
my lord.
probably it may appear to be a very trivial error. But in the commercial transactions of this nature.
Now, please come to
Court
page
should be-
44, the requirements of the tender. Lord, please come to page 44, the heading. Requirements for participation in online e-auction after compliance of A, B, C, and D as stated above. Lord, we are on C. C, your lordship will get, Lord, at page 45. Scanned copy of integrity pact duly signed in all pages by the authorized signatory who is signing the bid. As per format enclosed in annexure 6 of e-catalog is to be uploaded with qualifying requirement, and the same, i.e. the original integrity pact must be produced before issuance of the sale release order. Bids without scanned copy of integrity pact uploaded in injunctions portal shall be rejected outright. Essential terms of the contract, Lord.
97 of the stay application.
And if others
Lord,
are also
please see
there.
the note just below that, Lord. Please see NB, the note. The above mentioned documents in support of pre-qualifying requirement must be uploaded by the bidders on injunctions portal on or before the last date of submission of documents. Now, Lord, last date is over. Lord, 12 qualifying bidders have put in their earnest money deposit, 9.45 crore each. Bidding has started from 12 this morning. Now, the entire process will have to be scrapped.
Difficult.
No, I'm not saying it has
And
to be
but once
scrapped.
litigation starts, nobody else will now come forward.
My lord, what will happen? I will only be given to participate. That's all. How will it be scrapped?
Lord, one more
There's
page,
no
Lord, please
question
see
of
page
scrapping.
46. Please see page 46. It's in bold. Page 46. General instructions to the bidders. Number 1. All transactions entered into by the buyer or bidder arising out of this e-auction shall be governed by the Integrity Pact. It's an essential condition. And if I have to, Lord, make any deviation for one, I have to make deviations for everybody. Of course, I can't. It has to be rigidly followed. Ancillary condition, I could have made the deviation for everybody. But this is absolutely of the essence of the contract.
Yes.
We have found in DVC, Lord, the money which has been improperly procured, which is subject matter of Lord PMLA Act, is being utilized. Lord, the Central Vigilance Commission has directed us to follow Integrity Pact. We have received notice
Yes,
from the Central.
We have seen, we have decided one matter.
Hello.
Who are you, sir? Two.
He is the portal. Our point.
Once they had uploaded the
How do I know?
Rectify the defect.
How?
When did they file the writ petition?
So, well, 3rd July, I came to know. That's the point.
No, sir. See, it's not small time business.
No.
It is not 900
No,
rupees.
but
It is
can-
9 point some crores. So therefore, obviously, your client would have been aware that the entire document did not go through.
No, it did. That's what I'm saying, my lord. Kindly see page. Kindly.
No, no.
It went through. So if I know
We have heard
that,
you.
my lord, today, my lord, kindly appreciate only one thing. My lord, today, what fell
Today
from-
we can't interfere.
all I'm saying, my lord, all I'm saying is what? Allow me to participate.
Yes,
So,
that we will consider.
so
That-
my lord, the integrity pact has been given there, signed, all
All
pages, 2 pages did not go up.
This intra-court appeal by the writ petitioner is directed against order dated so-and-so WPN number.
The
so-and-so.
original is also with
The
us.
petitioner, the appellant had filed the said writ petition challenging the rejection of the tender submitted by the appellant as invited by the first respondent corporation. The reason for rejection being that the integrity pack has not been uploaded in full. The learned advocate would strenuously contend that it is not in dispute that the integrity pack was uploaded, but there were 2 pages were blank. And this came to the knowledge of the appellant only after an email was received from the first respondent corporation. It is submitted that the appellant has already deposited the EMD.
No, not deposited.
In the wallet, I
Not
have
with
it.
us, not with us.
Give.
Not received by us.
All right.
Yes. Well, it is there in the
Their
wallet.
own wallet. It is their own e-wallet.
Yeah, so that's all I can do. Otherwise, they will not.
By the learned
Not received
advocate
by
for
us.
the appellant that the earnest money deposit amount is ready and it is available in the e-wallet of the appellant.
Injunction portal.
So it's in the
Therefore, it is submitted
part two.
that the appellant should be permitted to participate in the tender. After we have heard the learned senior advocate appearing for the first respondent as well as the advocate appearing for the second respondent, we find that the document which was required to be uploaded in full was required to be signed by the appellant in all pages. And the said document is an integrity pact. In terms of the conditions stipulated in the notice inviting tender, more particularly under the caption, inverted comma, requirements for participating in online e-auction, inverted comma close, it has been mandated that scan copy of integrity pact duly signed in all pages by the authorized signatory who is signing the bid as per format enclosed is to be uploaded with qualifying requirement, and the same, that is original IP, must be produced before issuance of sale release order. Full stop. The condition further states that bids without scan copy of integrity pack uploaded in M junction, same words, M junction. It is in page 44. Okay. M junction's portal shall be rejected outrightly. There is a note which has been appended in below clause C of the said condition, which state that the documents mentioned therein in support of pre-qualification requirement must be uploaded by the bidders on M Junction's portal on or before the last day of submission of documents. However, hard copies of the documents will have to be submitted by the successful bidder / H1 bidder post e-auction to DVC. Furthermore, under the general instruction to the bidder, all transactions entered into by the buyer / bidder arising out of the e-auction shall be governed by the integrity pact as per Annexure 6 of the tender document. Thus, the document which was required to be uploaded in full was required to be signed by the intending bidder in all pages. And admittedly, the appellant having not complied with the condition, the question of now interfering with the decision of the first respondent corporation or permitting the appellant to participate in the tender would not arise. More so, in exercise of powers under Article 226 of the Constitution of India. Therefore, we find no good grounds to interfere with the order passed by the learned single bench. Accordingly, appeal is dismissed. Sorry. Next.
Appellate monthly list, Passover matter, serial number
Thankful
6.
for having accommodated
Thank you.
us, my lord, during lunch.
What, sir? What shall we do? Election.
Serial number 6.
Yes.
Lordship, if one humble submission, if that can be taken after the MCC matter, my only humble request.
Which matter?
MCC matter, which is item number 8, that is also a passed over item.
All right. First, you want 8 to be taken.
Yes.
Okay.
No, because I have received instructions.
You ask somebody to inform this is irregular. All hardship can come, because this bench is going to. Yes, sir.
And so far as the
my lord, I have taken instructions,
Ah.
but the first paragraph placed was paragraph number 6. That the telephone number of a political party is being used for the,
Yes.
yes. But on that, my lord, my instructions are, my lord, this has been withdrawn on 15th of June, 2023.
Which has been the phone number. The project is going on. Action.
Yes.
My lord, the second allegation was regarding my lord transfer, which your lordships would find my lord at page, I'm sorry, at paragraph 7.
Yes.
My lord, to that, my lord, with these new chairs, I think with some rubber.
Already informed. I don't know where from they procured it.
Very uncomfortable.
Yes, yes.
They'll change the rubber bushes. Probably this weekend they'll do it. Very noisy.
Yes, noisy number one, and number two, it's not comfortable.
Very uncomfortable.
What about that?
Yeah. We have to blame the Public Works Department. Intern the government.
No end to human wants and wishes.
Probably State Election Commission can do something. You are now in control of the entire thing.
Yes.
You can replace it with sofas, comfortable sofas.
I had the experience to work with them, my lord.
That's it.
Yes.
You know.
Now, that's paragraph number 7, my lord.
Transfer.
Transfer, my lord, instructions, my lord, has been sent on 24th of June from the office of the
Election Commission.
Election Commission. My lord.
And to reverse all the orders of.
Yes,
transfer. Okay. Then.
My lord, so far as my lord serial number, paragraph number 9 is concerned.
Yes.
My lord, the DM or the district panchayat election officer, my lord, has inquired into the matter, and it was reported that he was not the person concerned. He was not, my lord, distributing money for as a gratification for votes, but he was, my lord, paying basically alms to the beggars. This is the report.
Probably his granddaughter's birthday. He wanted to give gifts.
Let him disclose the source of these arms.
All right. What about that superintendent of police he is escorting?
Yes. Not
You shift him somewhere.
no.
And get somebody
On
else.
that, my lord,
The development, not I request, not I pray rather, that the IG BSF not maybe ask to not take charge of this district. This was the most sensitive district in the last election. 56 persons died within a span of 2 weeks probably. And I have indicated, the petitioner has indicated the police stations from which not these arms are being gathered.
no, arms, there is no allegation.
No, then is beef up the security.
Yes, yes, definitely it will be done.
Not a single paramilitary force has been requisitioned for this district. We all know that this is the most, yes, yes. This is one of the most sensitive districts in the state.
I need to take instruction.
I just
because
need to.
These my lord, aspersions that not a single central military force has been requisitioned for that district. I don't think that is correct.
No, what he says is, considering what has happened in the past, there may be.
There should be more, I mean, vigilance over there. That can be done.
What is being done?
I do not know. These apprehensions will not.
It's not apprehension. It's on. Not I just place not this document.
It is declared. That district has been declared as a sensitive district. Purva Medinipur has been declared.
Not please see, criminals not from 5 police stations.
Yes.
Indicated.
Milord, not the entire district, but Milord, as per the DPO's report, the portions, Milord, certain portions, Milord, have been declared as sensitive.
But 5.
Now, this, Milord, with respect, Milord, this has to be left to the people.
That is true, sir. But then what? It's not stopping. Even it won't stop on Saturday, I think. It will go on till next Monday.
Milord, I can, Milord, only say this, Milord, that generally, Milord, common people, these apprehensions in the common man, Milord, is bound to happen. I don't say that it is all.
Do something. See, that's why we said, even in the last order, we have said, we impose so much of confidence in the commission, and commission needs to do. You please allay all these things.
But these are being done, Milord. I cannot say much over here, but everything gets reflected in the newspapers.
All right, don't say.
Yes.
We'll also not
yes.
say.
So, Milord,
you also don't say anything.
Yes.
In the later, there are 5 police stations indicated where from these arms are not being filtered into
in
the
these
area.
petitions,
Kindly directs the central paramilitary force at least to take charge of the
highlighted certain incidents which, according to the petitioner, is in gross violation of the code of conduct. On when the matter was taken up in the forenoon, the learned standing counsel for the State Election Commission was directed to get instruction in the matter. Thereafter, when the matter was taken up, Mr. Kishore Dattul and a senior advocate has appeared in the matter. And with regard to the averment in paragraph 6 of the writ petition, it has been, it is submitted that on 15/6/2023,
is not in use.
the announcement about a scheme has been withdrawn, including the phone number which was shown in the posters. With regard to the averment in paragraph 7 of the writ petition relating to transfers and postings, it is submitted that on 24/6/2023, necessary instructions have been issued by the commission to the government to withdraw all the orders of transfer. With regard to the allegation in paragraph 9, on inquiry, it is submitted. No, it is submitted that inquiry was conducted and the allegation is factually incorrect. With regard to the situation which is prevailing in the district of Pura Medinipur, the petitioner has pointed out certain instances where the superintendent of police is alleged to have been acting in a manner acting in a manner which doesn't instill confidence, his official position. Furthermore, it is submitted that the said district is a very sensitive district, and already portions of the district have been declared as sensitive, and the matter should be brought under the direct control of the Central Security Force. In the light of the stand taken by the commission, which is placed on record, insofar as Pura Medinipur district, since the election commission has already identified few of the places as sensitive, it goes without saying that the security arrangements shall be adequately provided, and wherever additional requisition, wherever more number of central forces are to be deployed, necessary logistical arrangements, necessary arrangements may be made in this regard in discussion with the Inspector General of the Central Force, who has been nominated as the force coordinator. Such decision shall be taken by the commission within 24 hours from date. Once again, we reiterate what has been said in the earlier orders, that the commission should endeavor to do all within its means to ensure free and fair elections and preserve the purity of the elections, and the public shall have no apprehension in the mind to exercise their franchise on 8/7/2023. With the above observation, our writ petition stands disposed of. Next.
Serial number
IGBSF.
6 and 7.
IGBSF.
IGBSF. I said IGBSF, force coordinator.
Section 50, subclause 3, it says Panchayat Returning Officer shall, on being satisfied as to the genuineness of the notice of withdrawal and the identity of the person delivering it under subsection 1, cause the notice to be affixed in some conspicuous place in his office. This is the provision of withdrawal. However, there must be some recording satisfaction of the concerned officer who is receiving the withdrawal. No such recording is there.
But how to examine that? You just give us an answer for that. He has made some inquiry. 3 officers in the rank of special secretary have inquired into it. They find that there is nothing wrong. CCTV footage is there. So there should be some adjudication.
Only possible way that was, in fact, your lordship directed the constituted committee, independent committee, who can examine that. If the committee is
probably, what we can do is we can direct the commissioner to examine the video footage, etc., And
Video footage will not reflect anything like.
then what shall we do?
Like the committee who is appointed by this court, like, should examine us and
And
because somebody want to contest and the entire area remain uncontested.
In terms of the directions issued earlier, an unsigned report of inquiry conducted has been filed by the commission along with annexures. It appears that a team was constituted on 30/6/2023, and the nominated team had examined the records, and it is submitted that there is nothing illegal about the withdrawal of the nomination. Since the issue relates to disputed questions of fact, the same cannot be adjudicated in a writ petition. Nevertheless, we would request the State Election Commissioner to personally examine all the records, as also the video recording, and form an opinion and place the opinion before this court in a sealed cover. Let the matter appear next Tuesday.
Let them hear us.
Your lordship, may I?
Let them hear us, because otherwise.
Can't be done, sir. It can't be done.
Let the
Let
the office, we had made complaint that was not responded. At base, we can make a complaint that there is a threat to withdraw the commendation.
May I very humbly submit, your lordships? In Diamond Harbour, the petitioner was not heard because he said that there is a paucity of time and he cannot come over to the committee. But in Bhaduria, I'm under instructions, I'm submitting that she was heard.
Report says that we are heard. The report has been made
So
incorrect
this is what
statement.
I'm submitting under instructions.
That we want to contest. The area is uncontested. Let there be election. Without prejudice to anybody, let them not, let us contest.
Yes. We have heard you, sir. Yes, sir. Senior
Well,
Counsel.
yes. Item number 29, Mr. Dutt mentioned in the morning, there's a direction to make deposit of certain amount by Monday. Therefore, unless your lordship extends the time till next.
This is item number.
My lord, I appear for the
29 and 30.
respondents, my lord. May I just point out, my lord,
38.
and if your lordship kindly takes, my lord, item 29, your lordship will find after the judgment was delivered, a categorical submission was made on behalf of the petitioner that they seek 1 week's time to make the deposit.
That is recorded.
Yes, that is recorded. They cannot pray for any interim order. Well, that is specifically recorded. May I just hand up? May I just hand up? May I just hand up that particular portion? Well, they were enjoying a stay when the matter was made. Judgment was reserved. They did not pray for continuance of that stay order. Instead, they made a submission that we will make the payment. Give us 7
You
days
can
time.
do one thing, sir. You make the payment
Yes.
without prejudice. We will hear the appeal.
Not only one thing. If your lordship so directs, it's a question of security deposit. We have already given a lot of security. These were 19 crores and all.
That is different, man.
Wait.
Number, if something more is needed, not directly to say.
No, what we can do is, we can extend the time by another week.
Yes, sir.
You put in the money without prejudice to your rights in the appeal.
Not-
You fix the appeal in the week starting 17th.
70. I'm not kindly.
My lord, all other, my lord, may I just indicate, my lord? My lord, all other consumers have paid, my lord. May I just humbly submit? Instead of a week, kindly make it till Monday. Let them make that payment by Monday, my lord. Let them show their bona fide. My lord, they cannot take inconsistent stand in a course
Or
of
you can
litigation.
do one thing.
Yeah, let them pay.
You can seek for
And
extension
this is
of
bank
time.
guarantee, my lord.
Sir, wait,
I'm sorry.
sir.
I'm sorry.
You can seek for extension of time before the learned single bench also. That is not possible.
The petition is disposed of and he will be
So
found sufficient.
you do it by Monday.
Yes.
It is not. By Monday, if your lordship so directs, kindly direct us to deposit it with the.
No.
Otherwise, I tell you, lordship, kindly take it up on Monday. Otherwise, it becomes infructuous really.
No, it doesn't become.
Yes,
It's a point of law to be canvassed before your lordship.
it appears to be a consent order.
Yes.
Please,
No, no, question
either
is-
you seek for extension of time to comply with it and argue the appeal, or you say If you do say, I won't comply with it, then we will hear the appeal only when it comes up next week.
Only thing is subject to correction by your lordships. There has been a number of decisions that simply asking for an extension does not deter me from preferring this appeal.
No, it
So,
says
Yes.
prays for a week's time to
Yes,
put in the
yes,
deposit,
yes.
since otherwise the petitioner's electricity connection may be disconnected.
Yes.
So you put in that, we are ready to hear your appeal. Without electricity, you can't run the industry, sir. He is virtually a partner in your business.
Yes.
Lord, may I put this question to myself?
Yes, sir.
Will they be prejudiced in any manner by 2 days? Except Monday, kindly fix it on Wednesday. If Wednesday your lordship dismisses my appeal, we'll
Well,
do
let them show
We'll do
the,
it.
it is only bank guarantee. Then it's a cash deposit.
Yes, cash deposit.
Or BG also. Let them submit a BG bank guarantee. That will do.
It is as good as cash.
That's right.
But it may be 80%, man.
Don't know.
The problem, the difficulty which we are facing right now, my lord, with these kind of, when these kind of orders are passed, these consumers are now migrating to other electricity distribution companies. My lord, we are facing this difficulty in many matters. So, my lord, let them show their bona fide, let them make their deposit, and let.
It's a question of security deposit. So, Lord, if we put in after 2 days, instead of Monday by Wednesday.
Nothing, my lord, they cannot get this extension in this court, my lord.
Sovereignty loss, and kindly hear it out on Wednesday.
We have heard Mr. Parthasarathi Sengupta, learned senior advocate appearing for the appellant. The appeal cannot be heard today for want of time. And the learned senior advocate prays for interim protection in the meantime, since as per the orders passed by the learned single bench, there's a deposit has to be made by the appellant not later than 10/7/2023. It is pointed out by Mr. Mazmundar appearing, learned senior advocate appearing for the respondent, that the appellant had agreed to make the deposit, had agreed before the learned single bench to make the deposit, and that was recorded and time was granted. Considering the submissions on either side, we extend the time for making the deposit by the of the requisite amount by when this will come only on Wednesday. Not later than 14/7/2023. Let the appeal be listed on 19/7/2023. We make it clear that if the deposit is not made within the time permitted, no, don't say that. The Supreme Court will say,
Kindly fix it on next Wednesday.
no, we give you 1 week.
If I lose, we lose.
No, we give you 1 week time.
No, that's right. It's a question of time to make deposit.
14.
But I say, Lord, before that, if your lordship.
No, so we can't, sir. Our full panchayat.
Next week there will be no panchayat.
No. So
It
we wish and pray your words come true.
It shall. Therefore, Lord, kindly fix my matter on Wednesday, and I tell you, lordship, it shall.
You pay and come.
Lord, Wednesday, Thursday, any time, Lord, next week.
Nice to see you appearing.
Keep your blessing.
Always you are appearing online.
Lord, it's always a pleasure and privilege to appear before your lordships in person.
Very nice. Thank you.
Lordship, before rising, item number 31 in today's list, Mr. Amitesh Banerjee, early in the morning, first sitting of Lordships, he has already mentioned the matter. There is grave urgency, Lordship.
Item
31.
What is the grave urgency?
Lordship, an order has been passed, Lordship, wherein the petitioner has been given a blanket protection of no coercive actions to be taken against the petitioners in any of the affairs. And under the veil of this, he is fully taking advantage of this order, Lordship.
We'll see whether who appears for the respondent. See how we can take up a 210. You can't expect him to be.
No, Lordship, if Lordship kindly keeps it tomorrow morning, We'll intimate the other side, Lordship.
Monday it will come. Monday.
Monday, Lordship, it will be because
Want to arrest him tonight.
Only one appeal to my lords, and I have item 24. A lady who is a resident and was staying in USA has to came, and my lord faced a proceeding. My lord, some urgency is there.
Monday.
I leave it to the court. I do not say any
All right,
time.
2 matters on Monday. Per matter and sir.
24.
My lord, item number 23, my lord, this is a challenge made in the particular notification of the SHG group, my lord, self-help group, my lord. That is, my lord.
That will come on Wednesday. Same position it will.
Same. Great.
Appellate side monthly list fixed at 230. Monthly list.
Yes.
We have got an instruction from ministry.
Yes.
আমাকে কপি একটা দিচ্ছি পার্সোনাল লেটার পরে আমাকে জানেন সেগুলো নিয়ে আমার একটু চিঠি চেক করে দিই ঠিক আছে Lord, the instruction says then 3rd July the balance 485 companies were requisitioned. But in spite of 2 letters issued to the election commission, no deployment plan was given. On 4th July at 9 p.m. This deployment plan was sought. Now, one difficulty has arisen. I had a talk with the additional secretary even at 1 o'clock. That they have arranged all and taken all steps. Even they have, your lordships have seen that they have written to the chairman railway board for dispatching these board trains. But some difficulty, my lord, may arise for the entire force to come to West Bengal before 8. That is the difficulty, my lord, I have given instructed to apprise your lordship. And since the deployment plan was served upon the election commission at 9 p.m. on 4th July, the other instructions were
At least 80% will be able to.
yes, that will be there. We are trying our best to mobilize all
What the letter says. All efforts have been taken for ensuring that out of the remaining 485 companies, maximum number of companies reach their respective place of deployment well on time for the West Bengal Panchayat election.
Yes.
Draw your attention so and so direction we issued ISO for deployment to all polling stations of the Panchayat election 2023. The IGBSF has been asked to take necessary steps for deployment of the companies covering all police stations in consultation with State Election Commission WB. Also, Chairman Railway Board has been requested to provide sufficient number of special trains for movement of remaining companies for the Panchayat election. I think they will be able to reach at least
And
by.
this is the second time the Home Ministry has requested the Chairman Railway Board to provide all such arrangements for deployment and so that they can reach before 8.
If they reach by tomorrow evening, I think.
That will be sufficient. All right. Additional solicitor. Deputy Solicitor General wants to say something.
Meeting, my lord, after reading this report, my lord, this is happening on a number of occasions. It is very embarrassing for us also, my lord, to come back every time, my lord, and trouble your lordships, my lord, with this facts, my lord. It was, my lord, ideally, my lord, everything would have been solved, my lord, had there been a multi-phase election, my lord, or had the dates been postponed of the polls, because it is well known now to the State Election Commission also. Initially, it was said that only no central forces are required. Then 22 were requisitioned. Thereafter, suddenly 822 without any basis. Now, despite our several requests, the deployment plan is being provided at the last hour, 9 o'clock on the 4th of July. So we cannot do anything before the morning of the 5th. So the forces have to be assembled at a common point in West Bengal. Thereafter, they will be sent to their respective polling stations or respective duties. It was incumbent on part of.
No, this deployment will take place from the neighboring states or they have to come.
The central forces have been requisitioned as well as forces from the other state armed polices. They have been also requisitioned.
No, the central forces, at least a good number will be stationed in each of the states.
Paragraph 3 of the instruction says, finally, our state nodal officer received the district-wise deployment plan from Additional Secretary. This is district-wise deployment.
No, the deployment from where the forces have to come. Different locations.
Various places. It may be Sealdah station, Howrah station,
outside
parts of the country.
ITBP is there.
Yes. It is given here. Assam, Bihar, Jharkhand, Tripura, Mizoram, Arunachal Pradesh, Maharashtra, Nagaland, Chhattisgarh, Punjab, Rajasthan, Haryana, Karnataka, Gujarat, Goa, Tamil Nadu, Chandigarh, Kerala, Andhra Pradesh. Entire India is moving. Oof.
Extraordinary circumstances that had fallen, my lord, from the honorable bench also, my lord, of the last occasion.
Not in view of the present scenario, not I believe that 2013 situation was the best possible way out for the purpose of eradicating all disputes or not the stalemate. Not in
Yes,
that-
Mr. Krishna Kumar is also there. Guru Krishna Kumar.
Lords, just two things I wanted to highlight to my lords, my lords.
Yes.
My lords have been really, my lords, kind enough to ensure that, my lords, the letter and spirit of the order is complied with.
Yes.
Two things are, in my respectful submission, probably may require some amplification by this honorable court, my lords. One of the critical components now, my lords, apart from the polling booths where my lords have ordered that central forces must be present. I understand a very critical component of this entire exercise in the process is when, my lords, the ballot boxes, my lords, are shifted and handed over to the receiving sections, my lords, and then kept in, my lords, the strong rooms. I believe there is scope for tremendous amount of, my lords, manipulation and malpractice or some kind of problems arising, my lords, in that exercise. That is one, my lords. The second aspect, my lords, is the safeguarding and the security, my lords, and monitoring of the strong rooms themselves. Because between the date of, my lords, polling and the date of counting, these strong rooms where, my lords, the ballot boxes are kept. I understand, my lords, those are again, my lords, critical days where, my lords, it will be very essential that central forces
Counting, we'll ask the commission. Sir,
yes, counting also, my lords, counting also.
Counting is centralized or how it is going to be done?
I'll just take him, sir.
Your officer is there.
The boxes will be brought to several receiving stations. But that receiving station, after 2 to 3 hours, from the receiving centers, they.
The counting
But
is
it's really like
centralized
this.
blockwise.
Blockwise.
Counting is centralized blockwise. In fact, my lord, the report to that effect, my lord, I'm instructed was submitted to your lordship's court, my lord, earlier. But my lord, the counting is centralized blockwise.
Okay,
Blockwise.
Process goes
Then
like
that process also needs to be videographed.
Yes, yes. Lordships have already directed that. And said that, my lord, so far as the, my lord, Central Armed Police Force is concerned, they will now be deployed through the entire election process, which will end with, my lord, declaration of voting results. That your lordships have made it clear.
We were submitting, my lords, that whatever aspects we highlighted would require some kind of specific amplification and clarification. Because only then, my lords, the process of shifting, my lords, to the receiving sections and stations, and thereafter, my lords, to be kept in the strong room for a period of 2 days, then brought, my lords, for counting. And during the counting process in the area.
Sir, one clarification we'll ask.
Yes,
What's the date on which the counting will commence?
11th of July.
11th of July.
11th of July throughout the state.
Throughout the state, yes.
Counting will start.
Counting will start event.
And probably it will be over in 2 days.
It will be concluded.
Evening itself it will become.
There is the problem in the last commission. That my lord, they are delaying the process and they continue this, my lord, the counting to the late night. Unhappened thing has been occurred in last commission.
In that order. My lord, it starts at 8 PM and it's concluded on the same day, 8 AM and it's concluded on the same day. First, my lord, is Gram Panchayat, then my lord,
Panchayat Samiti.
then Panchayat Samiti and then Zilla Parishad.
Therefore, two things I wanted to highlight, my lords. This process, what I mentioned, my lords, from the date of polling, my lords, till the counting exercise is completed, my lords, it's absolutely essential, my lords, and necessary that central forces are there to monitor, my lords. There is one other important aspect I wanted to highlight, my lords, and this is born out of the past experience. The post-poll violence which the state has witnessed, my lords, which is unprecedented, even in the last elections. Number of lives were lost. I would respectfully submit, my lords, it's a clear case, my lords, where the presence of central forces will be warranted at least for 2 weeks after the election results are announced, my lords. Because this honorable court has taken note of my lords, post-poll violence, my lords, and ordered inquiry. Now, massive number of people had died in the previous elections.
On what date is the results will be declared?
We see today, my lords, they mentioned that it's on the 11th. Because it's all physical ballots, I'm not too sure, my lords, whether the exercise will get over as they are claiming.
So it will be probably on 13th.
Maybe, perhaps, my lord. But I would think at least 2 weeks, my lord, since the date on which all results are declared, my lords, which is a very, very critical period, because election after election, my lords, the state has witnessed something which is very, very peculiar. In fact, in this election process itself, my lords, we have unfortunately lost lives of up to 17 or 18 people, which is better than, my lords, what it was earlier, thanks to my lord's intervention. But that is no consolation, my lords.
That requisition can be made.
I don't stand in the way at all, but my lord, I am told that 11th, 12th by these 2 days, my lord, in fact, 11th itself should be, my lord, the date on which, my lord, results are declared. But my lord, let us take one additional.
Between 11th to 13th.
Yes.
I'm really talking about the period post, my lords, to 13th. In fact, our apprehension is, my lords, even on the day of polling, my lords, there is real apprehension and chance, my lords, of violence. And that is the reason why, my lords, we have throughout insisted that, my lords, there's intervention, the forces are deployed.
No. Learned Additional Solicitor General has handed over in a written instruction given to him.
Yes.
By the director of the Ministry of Home Affairs.
Yes,
where he said for deploying to all polling stations of the Panchayat elections 2023.
Very well, my lords. I'm obliged for that.
Your concern is the safety and security of the ballot boxes.
Correct, my lords.
Soon after it is sealed.
Yes.
And in the process of being shifted to the receiving stations.
That's right.
Safe custody in the receiving station.
That's right.
Least for 1.5 days.
That's right, my lords.
8, 9, 10, 2 days.
Yes.
2 days, my lords. Yes, 2 days.
The counting will commence by 12th. I think it should be over.
Yes, should be over.
Yes.
So it is better that you retain the forces.
There is no difficulty.
Because I'm also talking of this period after the 12th, my lords. We are looking at least about 2 weeks, my lords. That's the request we are making to the court, my lords. Because this is something where we would respectfully submit, my lords, the sagacious intervention of the court will be very necessary.
Soon after the election results are declared,
yes,
the successful party will take out victory processions, etc.
Right.
There may be some disturbance.
Well, once your lordship has asked the forces to be deployed, and the forces have come, or in the process of arriving, well, it is entirely up to your lordship, till what time your lordships deem it, my lord.
No. A commission can make an assessment.
Jurisdiction ends only with the declaration.
Well, the commission's jurisdiction ends with the declaration results. After, my lord, after that, if your lordship feels that, my lord, there should be some protection granted for the period.
They can remain for at least a week's time.
Well, that is, my lord, beyond, my lord, the jurisdiction of the election
commission, but we can issue a direction.
Yes, that is, my lord, entirely for the court.
Central
I bowed on.
Retain the force for a reasonable time.
Yeah, I bowed on. Because that's a very critical period, my lords.
In fact, that we can't be deciding what will be the critical period.
Yes.
We leave that decision to the IG, BSS state nodal officer, because by then he will have a sufficient material or
we
data.
have received a communication from, my lord, the BSF, my lord, which provides for district-wise deployment of, my lord, the Central Armed Police Forces. But, my lord, we don't have anything, my lord, so far as the polling stations are concerned, deployment per polling station. But your lordship had directed, my lord, that this decision will be taken by, my lord, the IG of BSF.
No, in this annexure, but actually that decision has to be taken both by the commission and the IG.
Yes.
Because the commission will know, let us assume it's a big district, Murshidabad. So how many areas, how much are the sensitive areas? So they can say so many, such amount of force can go to this district, this district. That logistics you need to work out.
Well, But I'll tell you,
can't in a
Lordship, my lord,
writ
the
petition now.
only thing that I don't want to, my lord, once again, my lord, come up against is, my lord, allegation of, my lord, my lord, behavior undeserving of the election commission. Now, my lord, what has happened, I pointed out that, my lord, even with deployment of 485 companies, only about 65,000 forces come. My lord, we have about 65,000 polling booths. So, my lord, your lordship had said that, my lord, today, although 50-50. Now, my lord, even if one, my lord, personnel is deployed per polling booth, but in that case, my lord, 50-50 will mean only 1 and 1. My lord, that possibly is not your lordship's intention. So, my lord, let the BSF decide as to, my lord, how to man the booths, because we can't, my lord, if we say.
So, first of all, they'll, of course, the IGBSF is now stationed here.
Yes.
He is here. So by now he would have made a study of the entire area. Probably the commission can hold one discussion. As and when forces arrive, they can be rerouted to places.
Yes.
That we can leave it that discretion to you, and you
The
can,
difficulty will be, my lord, today, if we consider particular booths to be sensitive, my lord, we will consider deploying, my lord, larger number. But in that case, some, my lord, polling booths will remain unmanned by, my lord, state armed.
that you need to work out, sir, somehow. So that is what the last occasion you said, the mobile force.
That's right. Well, that was our suggestion, but, my lord, with allegations coming fast and loose, my lord, I, my lord, do not want to fall foul of, my lord, the court's, my lord, intentions, because, my lord, I want, my lord, to ultimately work as per the court's directions, because, my lord, of these allegations. Now, my lord, I thought, my lord, perhaps in these circumstances, it would be best, my lord, if we have mobile units of, my lord, armed police forces, which will, my lord, be covering, my lord, about 6, my lord, polling stations. So, my lord, each of them can, my lord, very conveniently, quickly, my lord, visit, my lord, 6 polling stations in about half an hour. That is, my lord, our estimation. But, my lord, the difficulty will be that, my lord, they will not in that case be stationed in, my lord, particular polling booths, which then will have, my lord, the state armed police forces.
No, suppose they have got the walkie-talkie facility, etc. Assuming somebody plans a violence. They know this team is going to come in another 15 minutes. They wait half an hour, 45 minutes, 1 hour, 1.5 hours, like very obedient people. The moment the team makes a move, they proceed.
Possible.
So in that case, some SOS has to be sent to them. We cannot.
No, well,
it is best left to the IG, sir. And whatever the IG would like to advise, that the commission may examine. And of course, your additional director general is going to be there. There may be a couple of nodal officers appointed by the state as well. They can have a.
We can do that, my lord, but, my lord, then, my lord, just, my lord, expressing, my lord, what instruction I've received. My lord, in these circumstances, because of, my lord, absence of, my lord, large number of forces, my lord, because if your lordship says that every polling booth must have an armed police, my lord, force of the central, my lord, forces. In that case, my lord, it will be only about 1.
No, may not be. There are 44,000 booths, and there are
44,000
polling stations and 65,000 booths.
So, my lord, I leave it.
61,000 booths.
Well, at 40.
One polling station may have more than one.
More than one. That's right.
So one polling station will have, may at times have 3 or 4 100 booths.
So 44,000 polling booths.
Yes,
so that can be the base figure. With that, they can easily do it.
Yes. I will follow the instructions of the IG Malad in this regard. I will do it as Malad this way. And Malad, we will of course deploy Malad state police forces as per their Malad requisition or their direction.
Very well, my lord. Therefore, this part of it, my lords, as my lord pointed out, is really for those people on the field, my lords, to take a decision and give appropriate instructions on discussion, my lords. I want to stress again on that bit, my lords, after the declaration of results.
Yes, that we have made a note.
Yes, that's right, my lords. At least for about 10 days to 2 weeks, my lords, is what I would respectfully submit for my lord's consideration.
What do you want to?
That I want to say, my lords could consider at least, my lords, for 10 days to 2 weeks, my lords.
Yes.
That's what I was submitting.
Then you sort it out, no? You are the polling officer. He has appointed you as the polling officer.
Please hand over all your
At times, we
complaints.
have a slight doubt who's the election commissioner. You polling officer will interact with, there must be a district level officer. Something he is mentioning.
Well, whatever complaints are being addressed to us, we are looking into that.
No, this is not by the public. This is by your polling officer.
Oh.
He says, sir, some signature, etc. He is fearing his life, sir. That is the bottom line of it. Right from the day one, he is harping on that. Protect me, protect me, protect me.
Yes. We have already, in the NIC, we have already arranged for mass.
No, not that. He expresses some concern.
We have taken note, we'll look into this.
My lord, violence continues. My lord, 1% died yesterday. Was killed. My lord, bullets were fired in Jalpaiguri. My lord, I've just, my lord, brought about some pictures. My lord,
You take your word.
an urgent supplementary affidavit also.
What do you want?
My lord,
There is no place, sir, to keep all the papers. We will send it to your chamber.
my lord,
Safe custody.
my lord, they fired yesterday night at Jalpaiguri opposition party district president. A contesting candidate of Sira Rajpur Anchal Gram Panchayat was beaten by TMC goons. But in Birbhum, there a murder happened on the 5th of July. Yesterday, my lord, contestant from a Gram Panchayat was assaulted by the ruling party members.
And no case has been registered.
My lord, they are going to lodge complaints. Sometimes they have lodged complaints. The yesterday
So what they can register an FIR.
My lord, we really, my lord, it's becoming really difficult, my lord, in this situation. My lord, the murders have crossed 15 now. So, my lord, this is one difficulty. My lord, now also, my lord, a person who had come before my lord, a writ petitioner, he had filed the contempt because, my lord, contractual people were being appointed as polling officers. He's being threatened. He lodged a complaint with the Howrah Police Commissionerate and the Dasnagar Police Station. My lord, now if this is the situation, my lord, people will not come up before
the state. He says somebody is lodged a complaint.
My lord, here
because he has come to court, he's been threatened.
My lord, no, my lord, details, it's there, everything, my lord.
You give it to the council.
No.
You won't give it.
My lord, I'm prepared, absolutely, my lord.
You give a copy to him. About 1 hour before, if you had informed the council.
My lord, I was not, but my lord, the difficulties, my lord, the grounds, every time it's not, my lord appreciates the difficulty, my lord. Every time something happens, we'll have to intimate them. My lord, the situation on the ground.
All right, sir. It's not that all the police, the entire state police is here. He's a government council. For him to enable him to get instruction.
No, my lord, every time.
In fact, we have done that in the morning. 3 times we have passed out the matter and she was able to get some instruction. They filed a report.
Threatening to withdraw the matter. That's the difficulty. My lord, now, my lord, here, my lord, we've filed contempts which are there before, my lord, 2 contempts, my lord, Dipankar Rit and Shanmay Banerjee. My lord, contractual persons are still being appointed, my lord.
My lord, I'll tell you, Lord, may I just address this straight away? I've taken instruction. Now, my lord, what is a contractual employee? Let's understand that. My lord, different government offices, their officials, prepare a list of the employees. The database is more than 4.5 lakhs. Now, today there are times when we have found that, for example, an assistant professor has been appointed. Later it's found that he's a contractual professor. Immediately we've removed. But these processes are a continuous process. We have done away. Your lordship said on the last occasion, a sheaf of papers was handed over. We've scanned them and we have done away with all of them. Today there may be one or 2 aberrations, but this is how
this is becoming a routine for them.
All right.
With due respect. My lord, here, even as on 25th June.
Yes, sir, we have heard you. Please come.
My lord, one other.
You come here, we are not able to hear you. You pull the mic.
One other issue I'll just indicate. Today morning, someone mentioned the matter regarding the flag code violation and prevention of insults to National Honor Act. Certain that I'll just hand over the thing to the
All these
election
complaints,
commission.
you lodge it with the commission. Yes.
My lord, so for the second, my lord, the contempt application filed by us, my lord, regarding the videography and others, my lord, they have they filed a report that the prior to the 2 dates, my lord, they will install the CCTV and others, my lord, that is the one of the part. And second part is that, my lord, repeatedly there has been given the numbers and phone numbers and the list of the observer. But, my lord, at the time, my lord, when it was, my lord, we are trying to reach them, my lord, no one is responding the observer, my lord. This is the one of the, my lord,
But the numbers are given, no?
number given. The most of the time the mobile is switched off, my lord. In this situation, my lord, and my lord, yesterday I mentioned that regarding the violence, my lord, that is going on throughout the state.
Which district it was switched
My lord,
off?
I am specifically from the Malda and Murshidabad.
Malda,
And Murshidabad.
the observers
Mobile are most of the time are switched off at the time, my lord, when they required, my lord, to complain, or my lord, that time, sometime they were not, my lord, responding, and most time that is.
There is only one number or multiple numbers?
Multiple numbers, my lord. Multiple numbers. For the one person, one number, and
No, is the phone switched off or it is busy?
no, switched off, my lord.
At night, most of the night switched off.
And my lord, what
Especially at night.
what is thing, my lord, the undue incident, my lord, took place in evening, my lord. It is not in the office hours, my lord. Therefore, my lord, in the evening we can't reach them.
No. Observers are 24/7.
That is after evening, all mobiles are switched off.
But still he is a human being, no? He has to sleep for some.
That we understand. But at, my lord, the night, my lord, there are several bombing, my lord. These things are going on, my lord. Where people will go?
List of observers published in the website, published in the newspapers, multiple numbers given.
No, what he says is.
I understand, but this is something, my lord. We can, my lord, once again reach out to them and, my lord, ensure that they keep their.
Probably send them a message.
Yes.
If suppose he has to take some rest. The observer can't be like awake all 15-20 days
No,
without
my lord,
food,
I would
water,
expect
sleep.
that he would be, my lord, in a position to receive complaints
Yes,
at
somebody
24/7,
can.
as your lordships have
If
said,
suppose
but-
one number cannot be reached, those calls can be diverted to another number where one officer can.
That is exactly.
You can do all that, sir.
Another thing is that, my lord, pointing out that, my lord, in the name of the deployment of the state police, my lord, some person has been deployed. Those are the, my lord, they completed their training, my lord, of the only 3 months. They have not, my lord, now reached their designation of a police, my lord. They have been also deployed.
No. Training period is also service period.
My lord, for the 2 months, 1 month, the training,
Yeah.
my lord, they had been used in the election, my lord.
Except the profession, advocate profession, every profession requires a training. Am I right or not?
Yes.
If you want to become a full-fledged doctor, CRRI, compulsory rotatory internship has to go on to. No? If you want to become chartered accountant, articleship is required. Engineer, he should be on the field doing a project. In the final year, before his final examination, minimum 2 projects he has to complete on site. You examine all except the advocate profession. Every other profession requires training. Secondly, advocate profession is the only profession which does not require a certification after you get yourself enrolled. Every other profession has got a continuing education program. Medical CME program is there. So for you, suppose you're a doctor affiliated to, attached to an hospital. They are doing the grading. So the hospital applies for a grading. Then they will assess those doctors. How many of them have accredited themselves by attending to how many CME programs, continuing medical education programs. So that will add to the points for the institution. Same way AICT, when it does the accreditation, what is it? National board, I think. There is one for all engineering colleges. So ours is the noble profession which requires no certification, no training. You enroll today morning, 1.5 hours, you can commence your practice. That's good. That's good enough. Because the apprenticeship was introduced, but Supreme Court, it was challenged and it was struck down. Freshers can apply for, sit for the examination for civil judges, junior division, freshers straight out of the college.
But previously it was 3 years was must.
No, it's not.
Now there is another rethinking. Supreme Court has asked for the opinion of all the high courts regarding whether there should be a minimum years of practice to appear as. Because for getting a court control, unless you are in practice, because all these children, what they do is, moment they enroll, they start studying, preparing for the exam. 1 year of preparation, they crack the exam. They'll be enrolled probably with Srijib, he or she will become junior. But he will also give certificate. He was my junior. But never attended this chamber.
That's right. That's what happens.
So unless they focus and study, so we is the only, so even a police who is under training, recruited under training is also a police. If suppose he commits a mischief during the training, they can take disciplinary action against him.
So for the last
Okay,
but
only
least,
for my
my lord,
learned friends, my lord, information, I have just, my lord, been instructed that every district has, my lord, set up a control room, which is manned 24/7.
Okay.
And it's functioning already.
my lord,
And that control room number can be.
Control room numbers are already shared, but, my lord, already published in newspapers
No, but that
and in the
switch off,
websites.
এগুলো বন্ধ থাকছে।
that is
No, no, it's control room, observer, control room.
These will be a common order in all. These contempt of decisions were heard from time to time. And on the last hearing on 3/7/2023, certain directions were issued. On the said date, several parties were permitted to intervene, and their submissions were heard. And documents which were produced by those learned advocates appearing for the interveners were directed to be served on the Standing Council for the State Election Commission. In order to enable the State Election Commission to respond, the matter was adjourned and it's listed today. The learned Additional Solicitor General has produced a copy of the written instruction given to him by the Director within bracket Personnel, Ministry of Home Affairs, New Delhi, stating that the Ministry of Home Affairs has issued orders of deployment of additional 485 COIs, COIS, companies, no? C capital OYS, on 3rd July 2023. Further, it is stated that the State Nodal Officer, BSF, WB, while his letter dated 3rd July 2023 requested the State Election Commission, West Bengal, for district-wise deployment plan, and not having received any response from the Commission, and as time is the essence, the ministry-wide letter dated 4th July 2023 again requested the State Election Commission for the same. It is stated that finally the State Nodal Officer received district-wise deployment plan from the Additional Secretary and WBSEC level Nodal Officer appointed by the State Election Commission on 4th July 2023 at around 9 p.m. It is pointed out that the district-wise deployment plan is needed in advance for finalizing the movement of the companies. And after receiving the district-wise deployment plan on 4th July 2023, late evening, from the State Election Commission, all efforts have been taken for ensuring that out of the remaining 485 companies, maximum number of companies reach their respective place of deployment well on time for the West Bengal Panchayat elections. Further, the director has referred to the order passed by this court dated 4th July 2023, wherein directions have been issued to Inspector General, BSF for deploying the central forces to all polling stations of the Panchayat elections 2023. And in order to comply with the said order, the Inspector General, BSF has been asked to take necessary steps for deployment of companies covering all police stations, in consultation with the State Election Commission, WP. Full stop. The Chairman Railway Board has been requested to provide sufficient number of special trains for movement of remaining companies for the Panchayat election on top priority. Thus, from the written instruction received by the learned Additional Solicitor General, it is clear that the required number of force has already been deployed, and in all probabilities, the entire deployment should be arriving in the state of West Bengal by 7th July 2023. The issue would be as to with regard to the deployment. It is submitted by the learned senior advocate appearing for the SEC. Sir, you can abbreviate somewhere. State Election Commission, within bracket SEC. SEC, that there are totally 44,000 polling booths. In an earlier order passed by this court, the deployment plan was suggested so that the state police can also work in state police who have already been directed to work in tandem with the central forces be deployed on a ratio of 50:50. If the total number of the central forces deployed is more than 60,000, then it would be possible to cover all the polling stations. If not, all the polling booths, which are more than 75,000 in number. In our considered view, this arithmetic, inverted comma, has to be best left to the wise decision of the state level nodal officer, namely the Inspector General, BSF, who shall be given the necessary inputs by the SEC as well as by the top level officers of the West Bengal Police. The deployment can accordingly be made, as this court would not be this court would not have the expertise to deal with such issues. Mr. Guru Krishna Kumar, learned senior advocate appearing for the contempt applicants, submitted that though order that this court has passed orders regarding the deployment and other aspects on the date of poll, and other related matters, but the concern of the applicant is, contempt applicant is, the safety and security of the ballot boxes once they are sealed in the polling booths, and while they are being shifted to the strong rooms in the receiving stations, and after reaching the receiving station, to ensure the safety and security of the ballot boxes. Further, it is submitted that all counting centers should also be provided with sufficient deployment of forces, so that during the counting process, the safety of the ballot papers is preserved. The other concern which was expressed by the learned senior advocate is with regard to the presence of the central forces even after the date on which the elections, the results of the elections will be declared. It is submitted by the learned senior advocate appearing for the SEC that the counting of the votes will commence on 11/7/2023 and in all probabilities will be completed on the same day. Assuming there are certain issues, the counting should be over by 12/7/2023 and the results would be declared. On and after the declaration of the result, the role of the SEC stands concluded. Therefore, the concern expressed by the contempt applicant with regard to retention of the central forces post declaration of the results, election results, needs to be considered. The learned advocate appearing for one other contempt applicant would submit that in the circular issue by the SEC, there are certain aspects which are not clear, especially with regard to the signature of the presiding officer. The learned senior advocate appearing for SEC submitted that this issue will be addressed, and if need be, an additional circular in this regard will be issued by the commission. The submission is taken on record. The learned advocate appearing for the another contempt applicant submitted that the mobile numbers of the observers which have been made known to the public are not accessible, and in some cases the phones are switched off. In this regard, the learned advocate points out that this phenomenon has occurred in two districts, namely the district Malda and district Murshidabad. The learned senior advocate appearing for SEC submitted that this issue will be examined, and it is submitted that in addition to the observers being nominated by the SEC, in all districts centralized control rooms have been established, and the phone numbers of the control room have been widely publicized. If there are any technical difficulties or other personal difficulties of the observers, alternate arrangements can be made so that the mobile numbers which have been made known to the public to report about any untoward incident or any other concern can be addressed then and there, so that there is no room for any complaint. This aspect also shall be examined by the State Election Commission. As this court has been time and again pointing out that the duty cast upon the constitutional body, namely the SEC, is to ensure free and fair election and to protect the purity of election. The election process would stand concluded only after the publication of the results. So therefore, until then, the State Election Commission should ensure that all is done to ensure to prevent any complaints from any quarter. And it goes without saying, the safety and security of the ballot boxes, the safety and security of the receiving stations where the ballot boxes will be stored. Ballot boxes will be kept after it is being received from the respective polling stations, and also during the counting process until the declaration of results. So therefore, the SEC, the officers of the SEC shall hold discussion with the IG, BSF, State Nodal Officer with regard to the deployment of the central forces while ballot boxes are being transported to the receiving station to safeguard the ballot boxes in the receiving station, and when the counting takes place, and also till the results are declared. A clear plan of action be charted out in this regard, and the advice given by the Inspector General BSF from a state nodal officer shall be taken into consideration so that the matter, so that the deployment and other aspects goes on seamlessly. The learned senior advocate appearing for the applicant submitted that the applicant has a genuine apprehension in his mind that there is every likelihood of post-poll violence considering the past experience. Therefore, it is the prayer that the central forces should continue to remain for a reasonable period of time, even after the declaration of the results. In this regard, the State Election Commission will not have jurisdiction to make such a request to the central government, as the role of the State Election Commission would come to an end soon after the declaration of the results. Therefore, this court has to consider the said aspect and examine as to what directions have been issued. It is not in dispute that there were large-scale post-poll violence during soon after the earlier Panchayat election, as well as the election to the Legislative Assembly. Though it may not be right for the court to predict any such violence soon after the ensuing elections, but the apprehension in the minds of the applicant cannot be brushed aside. Full stop. As observed by this court in its earlier orders, it is the electorate which needs to be protected. And soon after elections and declaration of the results, if any violence erupts, it is the public who will be affected. Therefore, this court is of the view that the central forces shall continue to remain in the state of West Bengal for a period of 10 days from the date on which the results are declared. And in this regard, the Ministry of Home Affairs, Government of India, shall issue necessary orders and instructions to the state nodal officer, namely the Inspector General, BSF. All other subsidiary issues which are being brought to the notice of the State Election Commission or to any of the control rooms which have been established throughout the state, or to any of the observers who have been nominated by the State Election Commission, the same shall be taken serious note of and examined, and appropriate redressal and appropriate steps be taken to redress all such genuine grievances. Full stop. All that the court can hope is that the elections to the panchayats to be held on 8th July 2023 is peaceful, and the public will be entitled to cast their vote without any fear in their mind. List the matter on next Tuesday. No, you take order.
Next Tuesday.
No, you hand over to Mr. Saha, he will pass on.
One clarification with leave of my superior in office, kindly take the instructions that we have placed before your lordship. By way of the post-deployment plan, apart from specifying the number of companies that will be required, they have specified which company is exactly required for each district. Like for Hooghly, it has been stated that 5 companies of Shasastra Simapal, 10 companies of HY, 2 companies of Gujarat Police, 6 companies of Goa Police, 1 Mizo Police, Telangana, 2 Maharashtra. But this might create one difficulty for us. The number of.
That is why we said that the IG and them, they will sit and discuss. Because suppose a force is coming from Assam, they need not come up to Kolkata.
Yes.
Yes. They need not travel all, otherwise, and you deploy them to Murshidabad, to overnight train.
But
Create and those people, force also will become tired.
I want to kindly clarify, my lord, that since the number of companies required has been provided, now, my lord, the rest will vest with the force coordinator. That can be.
It is pointed out by the learned Deputy Solicitor General that the Commission, by communication dated 4/7/2023, has given a district-wise plan for deployment of companies of the central forces. The number of companies to be deployed have been mentioned in the said communication. As observed earlier, the arithmetics has to be left to be done by the expert, and we have entrusted the said exercise to be done.
By tomorrow.
Totally is 40. Additional 40. Sir? To be done by the Inspector General, BSF, the State Nodal Officer. Who will undoubtedly ascertain the views of the Commission and also that of the State Police. Then you say list the matter next Tuesday.
Next
4 p.m.
Next Tuesday will be.
But what about the ration, food, and other things?
Well, all these,
We are
all
taking
ground arrangements have been made. Well, to the extent that the Election Commission is supposed to make it, well, that has all been provided.
Authentic Bengali. At least when they go back, they should have a 60,000 people.
Just one aspect, my lords, one factual aspect. My lords had indicated at one.
We can send more.
With the compliments of the Election Commission.
Yes, with best compliments for Election Commission, Mr. Guru Krishna Kumar will receive some gifts.
I'll be obliged for that. Just one aspect, my lords, just one aspect. My lords had indicated in the order that the number of booths is about 75,000. I think it's actually 61,000 booths, my lords, around 61,000. The seats are 75,000.
So, Lordship had been recording Mr. Krishna Kumar's argument, submission. It has gone down as 75,000, 61,000.
61,000.
61 and 44,000 premises.
44,000 is correct.
But 61,636 is the exact number.
61,636.
61,636 is the number.
1 second.
I'll give you the exact number.
61,636.
61,636 polling booths and 44,382 premises.
44,382. 44,382 polling centers. 61,636 polling booths.
Counting of the guard.
And we read some people are saying that they are boycotting the polling, saying that they were not in a village.
10,000 people, who
you
say they're in the fringe of the village, they don't want to poll, cast their votes in the Panchayat election because they don't want to be identified as villagers.
No, actually, what I read from the news is that the request to be part of the KMC or Bidhannagar Municipal Corporation is still pending. See, only thing is, if it comes within the corporation limit, the amenities which is provided will be better.
Yes.
Yes, absolutely.
Your drainage system, then drinking water facility, street lighting, roads, which Panchayat will not be able to cater to.
Right, absolutely.
The state government, I hope, is listening to this one.
Yes, he is. No, he is also Bidhannagar. That is, he has got dual capacity. And yesterday's news is there are a lot of snakes
Yes, yes.
area and one fellow died also. And therefore lighting has to be improved. Monsoon. And they said the carbolic acid is being given in that kit. It's
Better
supposed
to
to.
keep the snakes away.
Maximum number of snake bite cases, two states, Tamil Nadu and West Bengal.
Yes.
Maximum number of snake bite death also, it's reported in Times of India, some newspaper I say, only Tamil Nadu and West Bengal during this season. Once the monsoon starts. And we have got our Madurai bench there. It's a permanent bench, 80 benches are there. It is truly a green campus. And we have got exotic birds. An exotic variety of snakes.
Here also we have exotic varieties.
No, not in the court complex.
Not the reptile variety. My land friend is referring.
And there is a water body inside the campus.
Yes.
And fish rearing takes place. And the fisheries department during the harvest, they will auction and all advocates will buy.
But I've been there, my lord.
You've been there? It's a very good campus. And the snakes,
Hotel.
especially cobras.
Yes.
Russell viper.
It's a very nice place.
Regularly they come and catch. The problem is we went and occupied their habitat.
Yes.
And now we are complaining that they are chasing us.
Madurai is a very nice place. Very nice.
This campus is very nice.
Campus is also very clean.
Large courtrooms. Good facility for the lawyers, canteen. The chambers are very good. Anyway, let us hope.
At least this process is completed, and then on Tuesday, your lordship will not have occasion to pass further directions.
We are obliged, my lords, for the indulgence and the intervention, my lords, which is really helping the process, my lords. It's really making a big difference to the process. We must say that.
No, that's because at the first instance itself, they made it clear
Yes.
that not here to stall the election.
Yes.
So that was clear. We recorded that in the first order.
Absolutely.
First order.
9th June.
9th June order, we recorded that.
That's right. I was there. I made that submission, my lords.
Therefore, we recorded the submission and
yes,
hope that things go on smoothly.
We are obliged for that, my lords. We are obliged. Deeply obliged.
Grateful to lordship.